Having to mention that
tomorrow.
mother of the applicant died. Mother of the applicant.
Tomorrow.
Pardon to mention, madam. The applicant is inside custody more than 7 years.
Tomorrow you make a mention. Yes.
Supplementary delete item 13.
In their direction for personal appearance, the IAC as well as the appellant. The last occasion is present, they are both are present in
Just a minute.
Process of naming.
who was contacted and asked you to attend the police station but did not respond. They are
Present in
present here too.
Yes, sir. Ready? और ना कौन
लोकनाथ सतनामी
तुमको आजीवन कारादंड ହେଇଛି
आज्ञा
भूली ଯାଇଛ କି
नहीं आज्ञा
ଆଉ ଭୁଲି ଗଲା ଭଳିଆ ଲାଗୁଛି
नहीं आज्ञा नहीं
ତମେ ବେଲ୍ 15/4/2002 ରେ ତମକୁ ବେଲ୍ ଦିଆଗଲା
आज्ञा
ତାପରେ ବର୍ତ୍ତମାନ ହିୟରିଂ ପାଇଁ ଆସିଲାଣି ତମର କିଛି ଇଏ ନାହିଁ ଓକିଲ ବାବୁଙ୍କୁ ତ ଇଏ କରି ଓକିଲ ବାବୁ ବି ଆପିୟର କରୁନାହାନ୍ତି କଣ ଉଦ୍ଦେଶ୍ୟ କଣ
आज्ञा
ଓକିଲ ବାବୁଙ୍କୁ ଓକିଲ ନିଜେ ଦବ ନା ଯୋଉ ଲିଗାଲ ଏଡ୍ ଆମର ହାଇକୋର୍ଟରେ ଅଛନ୍ତି ତା ତରଫରୁ ଆମେ ତମକୁ ଓକିଲ ନିଯୁକ୍ତି କରିବୁ ଯୋଉଥିପାଇଁ ତମକୁ କିଛି ପଇସା ପତ୍ର ଦବାକୁ ପଡିବ ନାହିଁ କଣ ଚାହୁଁଛ
वकील देखूं
ହଁ
वकील देखूं
ନିଜେ ଦବ
हाँ
ହଁ ନିଜେ ଦବ ମାନେ ଏ କେସ୍ ହଉଛି 2002 ମସିହାର
आज्ञा
ଆସନ୍ତା ସପ୍ତାହରେ ଶୁଣାଣି ହବ
आज्ञା
ହେଲା ତମେ ଶୁଣାଣି ଦେଖିବାକୁ ଚାହିଁଲେ ମଧ୍ୟ ଶୁଣାଣି ଉପସ୍ଥିତ ରହିପାରିବ କିଛି ଅସୁବିଧା ନାହିଁ
ଆଜ୍ଞା।
ଆଜିକାଲି ସବୁ ଦେଖି ହଉଛି
आज्ञा
ତେବେ ଓକିଲ ଯୋଉ ବାବୁଙ୍କୁ ଦେଇଥିଲ ଯାହାକୁ ସେ ବର୍ତ୍ତମାନ ଆପିୟର କରୁନାହାନ୍ତି ଜୟରାଜ ବେହେରା ଇଜ ଦେୟାର ଜୟରାଜ ବେହେରା ଅଛନ୍ତି
ଆଜ୍ଞା ଅଛନ୍ତି କିନ୍ତୁ is not
ଇଜ ନଟ୍ ୱେଲ୍ ବଟ୍ ହିଜ ଆସୋସିଏଟ୍ସ ଆର୍ ଦେୟାର SK ପ୍ରଧାନ UR ଜେନା SK ବେହେରା nobody is appearing ତ ଆପଣ ଓକିଲ ବାବୁଙ୍କର ଯାହା କହୁଛନ୍ତି କଣ ଟିକେ ଦେହ ଖରାପ ଅଛି
आज्ञा
ଯାହାକୁ ଦେଇଥିଲେ ତ ତାଙ୍କୁ ଦେବେ କି ଆଉ କାହାକୁ ଦେବେ କଣ କରିବେ ଆପଣ ଡିସାଇଡ କରନ୍ତୁ ହେଲା ଆସନ୍ତା ସପ୍ତାହରେ ଏଟା ଶୁଣାଣି ପାଇଁ ଆସିବ
आज्ञा
ହେଲା ଆଉ ଯଦି ସେଦିନ ଆପଣ କୌଣସି ଷ୍ଟେପ ନ ନେବେ ତାହେଲେ ଆମେ ଯୋଉ
କୋର୍ଟ ତରଫରୁ
କୋର୍ଟ ତରଫରୁ ଓକିଲ ଦେଇକିନି ଆପଣ କେସ୍
ଶୁଣାଣି କରିଦେବେ।
ଶୁଣାଣି କରେଇବେ
आज्ञा
ହେଲା
हाँ
କାରଣ ବେଲ୍ ଟାକୁ ଭାବନି ଖଲାସ ହେଇଗଲା ବୋଲି
नहीं
ହେଲା
नहीं नहीं
କାରଣ ଯଦି ରେଜଲ୍ଟ ଇଏ ହବ ପୁଣି ତମକୁ ସରେଣ୍ଡର କରିକିନି ଯାହା ପୁଣି ଭିତରକୁ ଯାଇକିନି ଭୋଗିବାକୁ ପଡିବ
ଆଜ୍ଞା।
ବୁଝିପାରିଲ
हाँ आज्ञा
ତେଣୁ ତାକୁ ଗୁରୁତ୍ୱର ସହିତ ନେଇକିନି ଯେମିତି ଓକିଲ ବାବୁଙ୍କ ସାଙ୍ଗରେ ପରାମର୍ଶ କରି କେସ୍ ବିଷୟରେ ସବୁ ଜଣେଇକିନି ତାଙ୍କୁ ଡିସ୍କସନ କର ଯେମିତି ସେ ଆସିକିନି ଆର୍ଗୁମେଣ୍ଟ କରିପାରିବେ ବୁଝିପାରିଲ
आज्ञा
ଆଉ ଇଏ କିଏ ଆସିଛନ୍ତି
IAS
ନା ଦିଅନ୍ତୁ ନା ଦିଅନ୍ତୁ
ରଶ୍ମିତା ପ୍ରଧାନ
ରଶ୍ମିତା ପ୍ରଧାନ ଇନ୍ସପେକ୍ଟର ଇନଚାର୍ଜ
ଏ ଥାନାକୁ ଡାକିଲା ବେଳକୁ କାହିଁ ଆସିକିରି ଆସୁଛି ବୋଲି କହିକିରି ପୁଣି ଅଟକି ଗଲ ସେଦିନ
ଡରି ଗଲି ଆଜ୍ଞା ଟିକେ
ଆଁ
ଡରି ଗଲି ଆଜ୍ଞା
ଡରିଗଲି ସୁଇଚ୍ ଅଫ୍ କରିଦବ
ନାଇଁ ଟିକେ ବାହାରେ ଥିଲି ଆସିବା
ତମେ
ଡରି ଗଲି ଟିକେ
ଥାନା ବାବୁଙ୍କୁ ସେଦିନ
ଏବେ ହବ ନାହିଁ ଆଜ୍ଞା
ଥାନା ବାବୁଙ୍କୁ
ଦୁବାରା
ସେଦିନ କହିଲ ଯେ ମୁଁ ଯାଇ ପହଞ୍ଚୁଛି
ଆଜ୍ଞା
ଏଠି ହାଇକୋର୍ଟରେ ଲାଇଭ ଷ୍ଟ୍ରିମିଂ ହଉଛି ଆମେ କହିଥିଲୁ ଥାନା ବାବୁଙ୍କୁ କହିଲୁ ଠିକ ଅଛି ଯଦି ପହଞ୍ଚୁଛି ଆଉ ଟିକେ ପରେ ଇଏ କରିବା ପାଇଁ ତାପରେ 2ଟା ବେଳେ ପୁଣି ଥାନା ବାବୁ ଆସିଲେ
ଆଜ୍ଞା
କହିଲେ ଆଜ୍ଞା ସେ ସୁଇଚ୍ ଅଫ୍ କରିଦେଇଛି
ସେ ଘର ପରେ ତାଲା ପକେଇ ଦେଇ ପଳେଇ
ତେଣୁ तार परिणति कौन हबो तमे जानिन खाली प्रथम थर ପାଇଁ ଇଏ ଅଛି ବୋଲି କୁହା ହେଇଯାଉଛି ହେଲା ବୁଝିଲ ତେଣୁ ଖାଲି ଭୁଲି ଯାଅନି ଆଜୀବନ କାରାଦଣ୍ଡ ହେଇଛି ବୋଲି ବୁଝିପାରୁଛ
ସେଇଟା ତମର ସୁବିଧା ପାଇଁ କୁହାହେଇଥିଲା ଆଜି ତମକୁ ଆସିବାର ଦରକାର ନଥିଲା ଆମେ ତମକୁ ସେଇଠି ଶୁଣିଥାନ୍ତୁ ତମର ସୁବିଧା ପାଇଁ ତମ ଜିନିଷ କଲା ବେଳକୁ ତମେ ଅସୁବିଧା କରୁଛ
misguided our brothers there.
ଓ
ଆଉ ଭୁଲ ହେବ ନାହିଁ
ଆଚ୍ଛା ହଉ
ଲେଖନ୍ତୁ ନାଟା Pradhan, the inspector in charge of Komna police station has ensured the appearance of appellant Loknath Sapnami physically in this court before us as per order dated 14/10/2025. On being 14/10/25 25 13/11/2025. The appellant number 2, when we made a query to the appellant number 2 as to whether he wants to engage any counsel on his own or continue with the same counsel or a counsel from the High Court Legal Services Committee shall be engaged for him to argue the criminal appeal. He stated that he wants to engage a counsel on his own and he will do the needful during the course of this week. A big apology for his conduct in not appearing on 13/11/2025 through virtual mode from Komna police station. Put up this matter on 25th of November 2025. If it is made clear that if the appellant Loknath Sapnami is unable to engage any counsel on his own, counsel from the legal firm engage or to argue the appeal. तो से ऑर्डर कलु जे तमे से दिन जो हाजिर हेलनी से तमे भूल मागिल एवं आमे तुमको प्रश्न कलु जे तमे निज तरफ वकिल दब ना हाईकोर्ट रो जो लीगल सर्विसेस अथॉरिटी अच्छी फ्री रे तुमको वकिल दिया जीवो तमे निजे कहलो जे नाइ मु मोर वकिल निजे देबी आसंता सप्ताह रे 25 तारिख दिन ए केस सुनानी पई उठिबो तेणु ता भितर तमे वकिल नियुक्ति करिबो जेंति वकिल आसी उपस्थित रहिबे वकिल बाबू तमरो यदि उपस्थित न रहंती ताहले आमे हमरो हाईकोर्ट लीगल सर्विसेस अथॉरिटी एंगेज करी हला केस ठीक yeah personal appearance of the counsel.
You'll be appearing.
Yes.
Hurry. Take breathe. Breathe comfortably.
Who mattered?
Hey, case re.
Yes.
You'll be appearing in this case.
Yes. Yes, sir.
Sit down.
Item number 13 जाओ सी वकिल से दबो आप वकिल दबो डिसाइड कर जो
आगे सत्य
हां
सत्य
ये
ନା ନା
ଦେଖିନି ଜାଣିଲି ଏଇଟା ତମର ଓକିଲ ବାବୁ ବୋଲି କହୁଛ
बोला सी वकिलात नामा करिया फाइल जा करिया कथा कर दियो
आगे
हैला ये
आगे
पेपर बुक prepare ହେଇଯାଇଛି have you if you want to receive the paper book you receive the paper
Yes, sir.
yes we are not in reflecting your name the moment you file the wakalatnama it will be reflected
Yes, sir.
if any land council enters appearance by filing the wakalatnama the name of the newly engaged council shall be reflected in the cause list Next of the earlier in this council, personal appearance of the appellant Loknath Sopnani, so also the inspector in charge of Pomna police station is dispensed with. Yes, next.
Item 1.
The report has come. Both of the appellants are alive.
Alive.
The report. Where is Mr. Devasnan Das?
Lords, I am appearing on his behalf, my lords. Lord,
Have you received the paper book?
no, my lords.
So receive the paper book, get ready
My lord.
for hearing. The land council for the state has produced the written instruction received from the inspector in charge of Chandrasekharpur police station.
नहीं सुपरटेंडेंट जेल खोर्धा जाए
Superintendent they not confined in jail.
IAC CS4 बोल दिया है क्या?
IAC देखी ना फिर कोड अपन लिखा है कितने जन आज appellant?
2 जन.
Two appellants.
Lipi alias Draupadi
Draupadi
Naik
And
and
Bagman.
Bagman. I have to honor to submit the non-summary development case have been registered. On inquiry, it was ascertained now the complainant is not remaining in the 40 area and it will not. As the case is older, it will be taken to action. As deserved few days found.
कहीं इस तरह
next. द्रौपदी गोटाका सुपरटेंडेंट जेल खोर्धा ଦେଇଛନ୍ତି.
ତା ପଛପଟଟା
ପଛପଟା. With reference to the I am to inform that
ସୁପ୍ରିଟେଣ୍ଡେଣ୍ଟ
that assailant no such are named Lipi is both are residing in Korea state. No such.
They are not confined in the in this jail.
ମାନେ ତ ବେଲ ରେ ଥିବ କି କଣ ଥିବ?
ସେଇଟା
They are
ବଞ୍ଚିଛନ୍ତି କି ନାଇଁ କଥା ହଉଛି ପରା କଣ ଆଣିଛନ୍ତି
ନାଇଁ ଆମେ ତ ପଚାରୁଛୁ ସେ ବେଲ ଯାଇଛି କି?
They are on bail.
ଯାଇଛି?
They are on bail.
Both of them are on bail.
No.
So their well-being. Are you in contact with them?
No, my lords, I'll take instructions if lordships.
one bail was granted as it appears on 2/5/2007 and two 2007 ପରେ ସେଟା ସେଟା ଗଲା appellant number 1 अच्छा appellant number 2 ଗଲା 26/2008 26/2008 A2 ଆଉ 2/5/2007 ରୁ A1 तो ବର୍ତ୍ତମାନ ଆପଣଙ୍କୁ ଆଣିବାର ଅଛି ତାଙ୍କର well-being ଆଉ ଏଇଟା କଣ ଆଣିକି ଦେଲେ not confined to jail ଆଉ ସେ complainant
they are placed from the Mangala case so that they are residing there address.
ଆପଣ କଣ ଆଣିବେ ଆମେ ଜାଣିନୁ ଆମେ we want the well-being.
One week
You said that both are alive. On what basis you are making such a submission? You have not yourself gone through this instruction. Just forwarded it.
1 week time.
Listen. It appears that the appellant number 1, Lipi alias Draupadi Naik, has been directed to be released on bail by the order dated 2/5/2007. Similarly, appellant number 2, Bagman Naik, has been directed to be released on bail by the order dated 26/2008. The Land Council for the state has produced the written instruction dated 27/10/2025 from Superintendent District Jail Khurda to show that both the appellants are not confined in the jail. Stop. The Land Council for the appellant state seek some time to obtain instruction regarding the well-being of the appellant. Put of this matter. Asunda Saptari Furia Sairu Niyasun on 25th of November 2025. Well-being report shall be obtained in the meantime. Pre-copy of the order be handed over to the Land Council for the state. Name Niyasun. Samir Swanso is present here. You receive the paper, submit that he has not received the paperwork. Let a copy of the paperwork be handed over to the Land Council for the appellant. Dastavat Negim de do hand over to them. So, କଟକର ଲୋକଙ୍କୁ ଆପଣ କଣ୍ଟାକ୍ଟ କରିପାରୁନାହାନ୍ତି ଓଡ଼ିଆ ସାହି ମଙ୍ଗଳାବାଗ ବଞ୍ଚିଛି କି ନାହିଁ ଦି ଜଣ ଯାକ those are young persons of course but in the meantime by the way 20 years have already passed so one may be at best 45 the other maybe nearing 50 years so I don't think so 25/11/2025 next
Item 2.
Oh, the report is there. The clause number 2. Report.
hey
The sole appellant.
Sole appellant.
He is alive.
The allied the appellant has been prematurely released on bail as per government order.
Yeah.
So we have to procure that.
huh?
Point number 1 is appellant alive present residing such
Let
an-
them do.
Point number 2.
Figure, the Land Council for the state has produced the written instruction dated 28/10/2025 from Inspector in charge of Munda Police Station, Raurkela, which shows that the appellant, who is now alive, has been prematurely released as per the government order. The written instruction is taken on record. The criminal appeal is disposed of. Yes, next.
Item 3.
Token received is not in proper. Then say Bargad ଥିଲା ସମ୍ବଲପୁର
କେତେ ଜଣ ଆଜିରେ ଜଣେ ନା କେତେ ଜଣ
ଆଜ୍ଞା
ଅଯୋଧ୍ୟା ଗଡ଼ ଜଣେ
ଆଜ୍ଞା
କେବଳ appellant କଣ ଆସିଲା instruction?
So ଦେଉଛନ୍ତି ଯେ Bargad received from district Bargad released on bail as per the colonel court order but did not provide any
Report that.
Item number
Clear ହେଲେ
273
273 ତ
Yes.
ଏଇ ଯୋଉଟା ଆସିଛି ରିପୋର୍ଟ ଅଫ ଡେଥ୍ ପରା କାହାର ଡେଥ୍ ରିପୋର୍ଟ କାହାର ଏଇଟା
ଏଇଟା ହଉଛି I beg to physically so it is ascertained appellant so was involved so has already expired
ହଁ
15/3/2018 ଆଇତ ଆଜି ଆମର ସେତିକି
ଆଚ୍ଛା।
ଦରକାର ଏଇଟା କଣ
କିଏ ଜାଣିଛି? ଏଇଟା କୋଉଠୁ ଆସିଲା
ଏଇଟା ହେଲେ ଯୋଉ ବେଲରେ ଯାଇଛି ଅଯୋଧ୍ୟା
ସେଇଟା କେବେ
ନା ଏଇଟା ହଉଛି ସେ ଯାଇଛି ବେଲରେ ଯାଇଛି
ବେଲ୍ ଆମର ସେଟା କଣ ଆମର ତ
ହଁ,
5/11/25 ର ଏଇଟା
ଏଇଟା ହଉଛି 19/8/2011 ବେଲ
ବେଲ୍
ହେଲା ତାପରେ ମରିଗଲା 18 ଆଉ ଲେଖନ୍ତୁ the Land Council for the state has produced written instruction dated 31/10/2025 from Senior Superintendent Circle Jail Sambalpur to show that the petitioner that the appellant has been released on bail on 19/8/2011 as per the order of this court. Stop. Another written instruction has been received from IAC Town Police Station, Bargad, dated 5/11/2025 to show that the appellant has expired since 15/3/2018. तापर से जो no near relatives करेगी ना separate service.
Sub item ଅଛି criminal appeal 374 2004
हाँ
କୋଉଥିରେ
single judge matter
274 जरा पुनी का
ସେଟା 3 years conviction ତା ସାଙ୍ଗରେ ଥିଲା ଗୋଟେ
ମାନେ ଇଏ ଲେସର ପନିଶମେଣ୍ଟ
lesser
that is disposed of matter
এটা সরিজি না
go to the single
the since we have disposed of अच्छा এটা लिख दो criminal appeal number 274 of 2004 since it's a single judge bench matter and the connected CRLA number 273 of 2004 has been disposed of today. The matter be placed with appropriate bench with the approval of the Honorable Chief Justice. Yes, next.
Item 4.
এটা আপডেট করি না 297 টাকা তাতে বের হয়েছি 13/5/2000 এতে জনেন না কে জন
ଜଣେ
ଗୌରୀ ଶଙ୍କର ଦାସ କଣ ଆସିଲା ରିପୋର୍ଟ
he is maintaining livelihood
staying with his family member at his village.
ଅଛନ୍ତି ତ ଆପଣ କିଏ so have you received Mr. Mishra paper book?
No.
नहीं जान
The state has
Mr.
not
D.K. Mishra and counsel for the appellant is present and counsel for the state has produced written instruction from Inspector in charge Junagadh Police Station to show that the appellant is alive. So the report is taken on record. Mr. Mishra and counsel for the appellant submits that he has not received the copy.
State has not also received the paper. State has not received the paper.
ठीक है. So also the land council for this station that they have not received the paper book. Let the paper book copy be supplied to the land council from the respective parties during course of the day. आज ही नहीं जान, है ना? Matter will be discussed next week for hearing. Yes.
Item 5.
We can instruct. এটা কোন আসিলা ଅଛି ନମ୍ବର
Full appellant.
his health condition is good
ଆଚ୍ଛା
staying in Mahanapatna ସବୁ ଦେଇଛି out of 2 doctors 1 is married
But criminal appeal 241 ଲେଖା ହେଇଛି that is the wrong because of ସେ ଯୋଉ 241 ଯୋଉଟା affidavit
ଏଟା
ଦେବାର ଅଛି
364 ଏଟା କଣ ଗୋଟେ
ନାଇଁ ସେ ଯୋଉ voting ଅଛି 241/98
ହଁ
ସେଟା କଣ ହେଇଛି ସବୁ ଥାନାରୁ ଆମ ପାଖକୁ ରିପୋର୍ଟ ଆସୁଛି ଏଇ 241 because
अच्छा मेन ऑर्डर टा जोटा ऑर्डर पास है अच्छा बट दिस इज अराउंड योर सॉर्ट ऑफ
PS case number GR number is
so we are concerned about PS case number 135 of 2002
that is the
PS case number 135
हाँ
अच्छा ठीक है लेकिन the land council for the
this relates to Bollywood
right
1%.
state has produced one so he's only you know
And paper book my lord
and paper book अपन भी रिसीव करना पेपर बुक सप्लाई कर दूं तो आज तो हियरिंग को स्टे
Item 6.
Item 6
Mr. Jagannath Patnaik
Sumitra Lalbihari died. Only Siddhartha Samal alive.
हाँ
तीन जन अछंदी
सुमित्रा और लाल बिहारी डेड सिद्धांत इज अलाइव मिस्टर
Only
नायक
Siddhartha.
only सिद्धांत इज अलाइव
My lord.
mainly
ସେତେବେଳେ ବାସ୍ତରୀ
the so all of the village so found that Siddhanta is alive.
ସେଟା ଗୋଟେ treasure
Whereas Sumitra Samal and Lal Bihari Samal have expired on etiki or ethic.
ନେକ୍ସଟ ରେ ସରପଞ୍ଚ ଦିଟା ଦି ଜଣ ପାଇଁ ଦିଟା ସାର୍ଟିଫିକେଟ
ଦେଖନ୍ତୁ the land council for the state has produced written instruction received from IAC Balini police station dated 2/11/2025 ढेंकानाल comma ढेंकानाल which shows that the appellant number 1 Siddhant Samal is alive, whereas the appellant number 2 Sumitra Samal and appellant number 3 Lal Bihari Samal are dead. The report is taken on record since none of the near relatives of appellant number 2 and here, president has abet kare so far as 2 or 3 is concerned. Paper book receive करचंदी paper book अपन receive करचंदी you are appearing for Mr. Jagannath Patnaik and Senate. A mention is made on behalf of Mr. Jagannath Patnaik that paper book has not been received. A copy of the paper will be supplied to the land council. ଆପଣ power ନଥିବ ବୋଲେ ଆପଣ ନାଁଟା ଦିଅନ୍ତୁ ଏବଂ ସେଠି ଦସ୍ତଖତ କଲା ବେଳେ ନା ସିଗ୍ନେଚର ମାରିବେ full signature on behalf of Mr. Jagannath Patnaik କରି ନେଇ Yes. जो आधे এটা कौन है ना हाँ A2 A3 dead और A1 alive हाँ next 7 number
Item 7.
Mr. Milan Kanungo brief अच्छी ना transfer is running Bharati Das
And in this case, total 3 accused person, 2 appeal. If total 3 accused person, 2 number of
ଦି
appeal.
ଜଣ ଅଛନ୍ତି 85 ରେ ଅମରେନ୍ଦ୍ର ଆଉ ସୂର୍ଯ୍ୟ ଅଛନ୍ତି
Yes.
ଆଉ 55 ରେ ହଉଛି ସିଙ୍ଗଲ
Single.
କଣ ଆସିଲା
55 ରେ ଏତେ instruction ଟା ଆସି ପାରୁନି.
ଆଉ ଏଥିରେ କଣ ଆସିଲା ବଞ୍ଚିଛି
Yes.
85 ରେ କଣ ହେଲା କୁହନ୍ତୁ
85 ରେ mallet.
I verified Surya Naik so and so
ଜଣେ ବଞ୍ଚିଛି ଜଣେ ମରିଛି.
expert ପୁରା
ଜଣେ
ହଁ Surya Naik expert ମାନେ Surya Naik ହଉଛି ଯୋଉ
2
appellant
appellant number 2
what about appellant number 1
alive ଲେଖିଛନ୍ତି.
Amarendra Mohanty is living acha so acha यार connected ଟା ହଉଛି ଜ୍ଞାନ ରଞ୍ଜନ ଦାସ
ସେଇଟା ଆସିନି.
ଆଚ୍ଛା ନେଇ ଆସନ୍ତୁ ସେଟା ଲେଖନ୍ତୁ ଏଇଟା ଲେଖିଦେବେ ତାହେଲେ CRL ନମ୍ବର 85 ହେଲେ ଏଇଟା ଲେଖିଦେଇ ଗୋଟା ଡେଟ୍ ହେଇଯିବ ଆବେଟ୍ କରିଯିବ ଆରଟା ରହିବ ବାକି ଯୋଉ CRL ନମ୍ବର 55 ରେ land council for the state seeks some time to obtain instruction regarding the well-being of the appellant ହେଲା put of this matter so and so ଆଉ ଗୋଟେ ଡେଟ୍ ଦେଇଦେଉ ଆପଣ କାହା ପାଇଁ
ମିସେସ୍ ବି ଦାସ
ହଁ
ମିସେସ୍ ବି ଦାସ
ଭାରତୀ ଦାସ ଆଚ୍ଛା ଆପଣ ଓକାଲତ ଇଏ ପେପର ବୁକ୍ ପାଇଯାଇଛନ୍ତି
ନା
ଆଚ୍ଛା
We have also not received paper.
ଆଚ୍ଛା ଲେଖି ଦିଅନ୍ତୁ so and so appears on so and so and for the land council submit that they have not received the paper book be supplied କର ତାହେଲେ ୟାଦେରେ ହେଲା A1 alive A2 dead Yes, next.
Item 8, my lord. Two items are there. In both the cases, I have only received instruction from the jail, not from the police station regarding the
Jail
one
ମାନେ bail ହେଇଯାଇଛି।
bail ହେଇଛି।
ଦିଅନ୍ତୁ ସେଇଟା ଇନଷ୍ଟ୍ରକ୍ସନ ଦିଅନ୍ତୁ କାରଣ ବେଲ୍ ଅର୍ଡର ହେଲେ ସେମାନେ ବାହାରିଛନ୍ତି କି ନାହିଁ ସେଟା ଗୋଟେ proof ହବ ଯେ ସେମାନେ ବାହାରି ଯାଇଛନ୍ତି as per the order of this court। ଏଇଟା ହେଲା 93 86
ସେ କହୁଛନ୍ତି ଟ୍ରାନ୍ସଫର ହେଇଯାଇଛନ୍ତି ପୁରୀ ଜେଲକୁ। ଖୋର୍ଦ୍ଧା ଜେଲରେ ଆମେ ବକଲାତନାମା ଦେଖିଲୁ, ଖୋର୍ଦ୍ଧା ଜେଲକୁ ଚିଠି ଦେଲୁ, ଖୋର୍ଦ୍ଧା ଜେଲ କହୁଛି ପୁରୀ କି ଟ୍ରାନ୍ସଫର ହେଇଯାଇଛି।
86 ଟା ବାହାର 86 ରେ ହଁ ବେଲ୍ ହେଇଯାଇଛି
ବେଲ୍ ସହିଛନ୍ତି ଆଉ ଜେଲ୍ କେମିତି ହବ?
ହଁ ସେ କିନ୍ତୁ ଆମେ ଚିଠି ଯୋଉ ଦେଇଥିଲି ଉଭୟଙ୍କୁ ପୋଲିସ ଷ୍ଟେସନ ଦେଇନା।
ତାପରେ ବେଲ୍
ବେଶୀ
2006 Jail Criminal Appeal 86 of 2005 किए फाइल करथिले? 3 जण फाइल करथिले। So order dated पाँच एक 2006 देखुची 2 जण को बेल ହେଇଛି ତାପରେ अच्छा ଆଉ ଜଣକୁ ବେଲ୍ ହେଇଛି ତାପରେ 25/8/2006 so ସମସ୍ତଙ୍କୁ ବେଲ୍ ହେଇଯାଇଛି
କେବଳ ପୋଲିସ ଷ୍ଟେସନ ତାର ୱେଲବିଂ ଫର ଆଉଟ୍
ଲେଖନ୍ତୁ
He is of considerable age, no? Then
CRLA number 93 so
ସେତେବେଳେ 69 years ଥିଲା ସେ।
ଏଟା କଣ କି
2005
ମୁଁ ଚିଠିଟା ଦେଇଥିଲି, ଚିଠି ଯୋଉ ହେଇଥିଲା
from your side।
ଏଇଟା ଟିକେ ରିପ୍ଲାଏ କିଛି
ସେ ରିପ୍ଲାଇ ଖାଲି ଦେଲେ ଯେ ଟ୍ରାନ୍ସଫର ହେଇଯାଇଛି ବୋଲି।
ନାଇଁ ଇଏ ଆଣନ୍ତୁ ଜାଣିଲେ ଆମେ ଲେଖିଦଉ ତ
93 ର
ହଁ 93 ଇଏ ଆଙ୍କ ଚିଠିଟା ଆଙ୍କ ଲେଖିଛନ୍ତି ସୁପରିଟେଣ୍ଡେଣ୍ଟ ସେ ଖାଲି କହିଛନ୍ତି ଜେଲରୁ ପଳେଇଲେନି ଆମର ଜେଲରୁ ଟ୍ରାନ୍ସଫର ହେଇଯାଇଛି ତ ଆଉ ଗୋଟେ ଜେଲ କିନ୍ତୁ ବର୍ତ୍ତମାନ ବେଲ୍ ହେଇଯାଇଛି ଆପଣ ଆଣିବେ ୱେଲବିଂ ଆଣିବେ ଆମର ଦରକାର ୱେଲବିଂ ଟା ଲେଖନ୍ତୁ criminal appeal 93 of 2005 the London Council for the State submits that he has received instruction from the Superintendent District Jail Khurda that the appellant has been transferred Who transfer
ପୁରୀ କୁ ଟ୍ରାନ୍ସଫର ହେଇଛି।
transfer to Puri jail
କେବର ଏଟା ଇନସିଡେଣ୍ଟ ସବୁ ଦେଇଛନ୍ତି ଜେଲକୁ ଗଲା ଯେ 6 ରୁ ଗଲାଣି।
କେବେ ଦେଇନି ଆଚ୍ଛା in your jail transfer ଆଚ୍ଛା 15 since 15/3/2005 however it appears that
order dated 18
এটা হচ্ছে অরক্ষিত মহাপাত্রଙ୍କ ତରଫ 93 93 টা 93 has been filed by Soul. However, it appears that the appellant Orokito Mahapatro has been directed to be released on bail by order dated 18/9/2006. Therefore, the Land Council for the State seeks some time to obtain the well-being report of the appellant. Semti taporata lekhondu 86 of 2004
ଟ୍ରାନ୍ସଫର ହେଇଛନ୍ତି
submits that the report again. This criminal appeal 86 criminal appeal memo has been filed by 3 appellants Vikari Chandra Mahapatra, Prashant Mahapatra, Gokul Mahapatra, who have been directed to be released on bail by this court by order dated 5/1/2006 and 25/8/2006. Land Council for the font ପାଇଛନ୍ତି କିଛି?
ହଁ
The Land
ଏ
Council
ଟ୍ରାନ୍ସଫର
for
ହେଇଯିବା
the
କଥା।
stated that he has received instruction from Superintendent District Jail Khurda dated 1/11/2025 that the 3 appellants have been transferred to District Jail Puri on 15/3/2005. However, he wants to obtain instructions regarding the well-being of the 3 appellants. Put up this matter on such and such day. Dita ko arjan hela well-being pai
Ma'am.
hela free copy dei jan
paper book
paper apon pai jan
No.
paper acha paper book supply kar do appellant ko next
Item 9.
Item 9 है instruction not received.
acha Land Council for the state seeks some more time to obtain instruction regarding the well-being of the appellant. Which of this matter out of date will come. Next, Catherine.
Item 10.
କଣ ଆସିଲା?
ବଞ୍ଚିଛି staying at ମଣିଷ ଛକ
June. Sole appellant Guttu alias Pramod Kumar Singh.
ହେଲା
He was granted bail on 21/5/2014. କଣ ଆସିଲା? ବଞ୍ଚିଛି?
ହେଲା
ଦେଖନ୍ତୁ, the Land Council for the state has received the written instruction dated 6/11/2025 from IAC Durga Bajar Police Station that the appellant so and so is alive. One is referring to also verified this on nothing about he is been running a fast food stall at Money Culture. Oh, the written instruction is taken on the phone. Advocate kiye kon de kon isse advocate ଦେଇଛନ୍ତି?
Action Act.
ହଁ ନା ଆର୍କେନାଙ୍କ ପରେ ଆହୁରି ବ୍ୟାଚ୍ ବ୍ୟାଚ୍ ବାଇ ବ୍ୟାଚ୍ ଦେଇଛନ୍ତି ଉଠିକି ଦେଲେ ଲାଟେଷ୍ଟ ଆସିଛି ବୋଧେ ପ୍ରଥମେ ସେ ଦେଇଛି ଏସ୍ ମହାନ୍ତି ଏବଂ ଆସୋସିଏଟ ତାପରେ ଆର୍କେ ନାୟକ ତାପରେ ଆସିଛି ଦେବାଶିଷ ପଣ୍ଡାଙ୍କୁ ଦେଇଛି ଆଉ କେହି ନାହାନ୍ତି ଚିନ୍ମୟ ମହାପାତ୍ର ତାପରେ ପଳେଇ ଆସିଛନ୍ତି
ଚିନ୍ମୟ ମହାନ୍ତି
ହଁ
ଚିନ୍ମୟ
ଚିନ୍ମୟ ମହାନ୍ତି ହଁ ଲାଟେଷ୍ଟ ହଉଛି ଚିନ୍ମୟ ମହାନ୍ତି ନାଇଁ ତାପରେ ସରିତା ଦାସକୁ ଦେଲେ 2014 ଆଚ୍ଛା ଦେବାଶିଷ ପଣ୍ଡା ଏନଗେଜ ହେଲେ 2016 ତାପରେ ଏସ୍ ମହାନ୍ତି ଚିନ୍ମୟ ମହାନ୍ତି ଏନଗେଜ ହେଇଛନ୍ତି 14/5/2019 ସେଟା ହଉଛି ଲାଟେଷ୍ଟ ସୋ ଚିନ୍ମୟ ମହାନ୍ତିଙ୍କୁ ଆମେ ତାଙ୍କ ନାଁ ରଖୁଛୁ ଆଉ ସବୁ କାଟି ଦଉଛୁ ଆଉ ତାଙ୍କୁ ଟିକେ ଜଣେଇଦେବେ ତାଙ୍କ ବିଷୟରେ ଲେଖନ୍ତୁ since Chinmay Mahanti and his associates have been engaged by the appellant on such and such Okalatnama which is the last Okalatnama filed on behalf of the appellant. The name of other counsel except the Chinmay Mahanti and the associates shall not be reflected in the cause list. এটা কোন আসলা রিপোর্ট কোন আসলা
দিল্লি alive with
আচ্ছা alive লিখছেন ঠিক আছে since Mr. Mahanti is not present the Land Council for the state submit that he will intimate Mr. Mahanti about the listing of the matter आपण पेपर बुक पाई जाइए
पाई जाइए।
ठीक है तांको कहबे यदि पेपर बुक पाई ना कलेक्ट करने
हाँ।
है ना and matter be added to the hearing stated so on yes next
Item 11.
I have not received the instruction, my lord. I seek some.
Srinivas Mahanti kuada gale Srinivas Mahanti B Panda U Sahi B Mahapato so on ये जो गोटिया वकालत नामा
sole appellant also.
सोल appellant वकील भी चेंज करना श्रीनिवास महांती को ये जॉन ही दियो
My lord.
हाँ नॉन ऑब्वियस
ମୁଁ ବି ଟିକେ ଟାଇମ୍ instruction ନେଇ
हाँ नहीं अपन टाइम दे दो हम कोई दियो तो यदि पेपर अपन पेपर ऊपर ले चलो
ନା sir.
अच्छा none appears for the appellant. The land council for the state seeks some time to obtain the well-being report of the appellant and further submits that he will intimate Mr. Srinivas Mahanti, advocate, about the listing of the case. He further submits that he has not received the paperwork. Let a copy of the paper will be supplied to the land council for this case. Matter will be listed. कोटे सप्ताह पर देगा 1 तारीख नहीं है 1 तारीख में तो 2 तारीख करते हैं 2/12/2025 well-being instruction regarding the well-being of the appellant be obtained in the meantime. Yes, next.
Item 12.
You will not see next week after this instruction ଆସିନି due to election.
Then
Next.
ସେ ଯୋଉଟା ଦେଇଛନ୍ତି ସେଟା ଆମର ଏଲଆର କେସ୍ ନୁହଁ ତେଣୁ ଆମ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବା ପାଇଁ କହିଥିଲେ ଯେ
Behra, land counsel for the petitioner, seeks 1 more week time to obtain instruction. Put of this matter urgent for you. Next. Attach fill up. Kota document. Solo podi. Solta kata podi.
Item 16.
Yes, sir.
This particular last occasion, my lord said that the delay of disclosure of the evidence of the eyewitness between 10. My lord, on that point, my lord,
Reliance was placed by them on a decision of the Honorable Supreme Court in case of Brahmanandanam. They are also 1.5 days delay and he has not disclosed about so and so. So that is how the even though it is a case where 6 persons were killed and death sentence was imposed by the Land and Trial Court, but this court has acquitted the appellant, the accused, mainly on the ground of delayed disclosure of 1.5 days. And it is further held that the murders were committed in the night of June 13, 1969. Yet C did not come out with the name of the respondent until the morning of July 15, 1969. So 1.5 days. It is not possible to accept the explanation sought to be given on behalf of the prosecution that she did not disclose the name of the respondent as the assailant earlier than July 15, 1969 on account of fear of the respondent. There could be no question of any fear from the respondent, because in the first place, the respondent was not a known gangster or a confirmed criminal about whom people would be afraid. Secondly, the police had arrived at the scene and they were stationed in the clubhouse, which was just opposite the house of the witness. And thirdly, ASI so-and-so was a nephew and he had come to the village in connection with visited the house. It is indeed difficult to believe that the witness should not have disclosed the name of so-and-so before police or even to the ASI of and should have waited till the morning of July 15, 1969 for giving out the names once. So, ଆଜିରେ ବି ଆଜିରେ ବୋଧେ ରାତିରେ ଘଟଣା ହେଇଥିଲା ଏବଂ ସେ ଡିସକ୍ଲୋଜ କରିଛି ଗୋଟେ ଦିନ ପରେ ଯେମିତି ଏଇ କେସରେ ସେଗୁଡାକୁ ରିଲାଏ କରୁଛନ୍ତି.
In this case, my lord, the PW11.
Yes.
May place your PW evidence of PW11.
Yes, of course.
In the chief, they are stating that some rivalry between them, that PW11 and for the out of the contest of the election. In the cross exemption, may I play with all the evidence of the PW11?
Yes, this is up to you.
PW11, there is a Yudhishthira Rautrai. I know all the
on what point we are now in
case disclosed. The PW10 has disclosed before the PW11 immediately. I have read to that. And there
who is PW11?
The Yudhishthira Rautrai.
No. You see, PW10 has stated before whom he has disclosed. One is he has stated that I have disclosed, I told about the occurrence before my family members as well as villagers. So this PW11 is one of the right. Please go on.
I know all the accused person. I also know the deceased Suramulya who was killed. On 19/10/98 at about 10:30 p.m. at night, the witnesses Akshay Pradhan and Ajay the PW7 came in a motorcycle to my house. The deceased Suramulya also came in the Luna moped to my house. We had a discussion about the political matter relating to the Yuva Congress meeting, which was decided to be held. I paid 200 to the deceased Suramulya for his pocket expense. At first, PW6 and 7 left my house in a Rajat motorcycle, and about 5 minutes thereafter, the deceased Suramulya left my house in a Luna moped. On the same night, at about 11:50 p.m., Sujit Naik, Roshan Parija, PW8, Akshay Pradhan, PW6, and Ajay Mahat, PW7, and Sujit Naik, son of Yudhishthira Naik, came to me and told me that the dead body of the deceased Suramulya was lying on the canal embankment. In the above person told me that all the accused person were taking liquor near Mysore Chowk, and the accused Kuttu alias Deepak had parked his scooter, and the co-accused Tonya alias Bijan had parked his motorcycle there. The above witnesses also told me that they had seen all the accused person following the deceased in their respective vehicle. They also told me that all the accused person were passing hurriedly through the canal embankment. The above witnesses told me that the deceased was killed by the accused person.
No, this ଏଇ ଯୋଉ ନାଁ ଗୁଡା କୁହାହେଲା 8, 6, 7 ସୁଜିତ ନାୟକ ଏକ୍ସାମିନ ହେଇନି ନଟ ଏଇ ଯୋଉ ଏମାନେ କଣ ସେ ବିଷୟରେ କହୁଛନ୍ତି ଯେ
କିଏ
କିଏ ହୋଷ୍ଟାଇଲ ହେଇଛି?
ଅକ୍ଷୟ ପ୍ରଧାନ
ହୋଷ୍ଟାଇଲ ହେଇଛି, ତାପରେ ଅଜୟ ମହାନ୍ତି ହୋଷ୍ଟାଇଲ, ଆଉ ବାକି ଯୋଉ ରସାନନ୍ଦ PW8 ସପୋର୍ଟ କରୁଛି, ଦେଖିଦିଅ ତାଙ୍କର ଯୋଉ ସେ ଶୁଣିଲା ନା ଆର ତ डिक्लाइन ହେଇଗଲା
ये क्रॉस रे डिक्लाइन
ଓ କ୍ରସ ନାଇଁ ନାଇଁ ଟିପରେ ସପୋର୍ଟ କରୁଛି କି? ଆରେ ଏଇ ବିଷୟରେ କହୁଛି ସେ ଯୋଉ କହିଲା ନା ଆମେ ଏଇଆ ମତେ ଆସି କହିଲେ ସେ ବିଷୟରେ ସେମାନେ
କହୁଛନ୍ତି I cannot say anything about the occurrence of this case.
ଓକେ ଠିକ ଅଛି, ତାପରେ ହଁ ପଢନ୍ତୁ. The above witness told me that the deceased was killed by the so-and-so. Yes, tapare?
I went to the spot after being the hard. I saw that the deceased was lying with the bleeding injury on his persons. There was spot injury on the neck as well as on the face and head. The accused Deepak Mahanti and his supported were being supported by the deceased Suramulia, and subsequently at the time of election, the deceased Suramulia supported me, leaving the accused Titu alias Deepak and his supporter. For that reason, the accused person had a grudge to the deceased for which he was killed. On 15/10/18, the deceased Suramulia had arranged one political program attend the ex-MP Southern South, and the said program was successfully. Due to the above circumstances, the accused person became envious with the deceased and caused the occurrence. Cross-examination.
No, where is that line that PW10 disclosed before him?
Yes, that's the paragraph 9 is there.
In the cross-examination.
But all I started my evidence in chief was not within my personal knowledge, and I was told by the witness about the same. I gave telephone message to OIC of the Sadar PS about the occurrence. Police came to the spot at 12:30 a.m. at night. As the IO was stated that I have sent one person. I was examined by the IO on the same night. I sent intimation to the family member of the deceased through Krishna Chandra Jana, that is the PW18. And other. I had not noticed any bicycle lying at the spot. I had seen a blood at the spot. I had seen the spot awaiting to the Pichu road. Paragraph 9. I had seen Tapos Mulia, that is the PW4, the son of the deceased on the same night of the occurrence at the spot. I know Prashant Kumar Behra, that is the PW10 that I witnessed. He told me about the occurrence on the same night of occurrence. Police came to our village on the same night of occurrence. I did not reveal before the IO that Prashant Behra PW10 told me about the occurrence. I cannot say if Prashant PW10 was examined by the IO on the same night or not. Some house intervened my house and house of the PW10. The deceased had told me on the veranda of my house about the political program. PW told me about the occurrence near the beach. I do not accommodate the deceased about 2 to 3 hours after the deceased left my house. I came to the spot. PW 6 and 7 arrived at the spot after my arrival. My house fall fast, and thereafter the house of the PW 10. If somebody come from the beach side, PW 10 had not crossed file. We were at the house. It is not fact that I have not stated before the IO that the deceased and the member of the political party asked me in our house to convene the meeting. The accused Tutu alias Deepak was one of the contesting the Sarpanch election, where I was also contesting among others. It is not fact that I have political rival with the accused Tutu alias Deepak, and that I insisted Tapos to lodge a FIR. I implemented the accused person. It is not a fact that the deceased Suramulia was ever associated with me in the contract business, and that he was over due to the paid any amount towards any such contract business, and that myself and PW are ever planned to away with the life of the deceased, and that we succeed in such plan. It is not a fact that I am disposing of falsehood. It is not a fact that PW 10 got any dealership being assisted by me. Parananda Vera is my Mamun is the purchase 12 PW 10 Prashant Vera is the son of the Parananda Vera. That the PW 10 has a disclosed before the PW 11
Occurrence. What is that?
No, I had seen Tapos Mundia, son of the deceased, on the same night of the occurrence at the spot.
No, we are not. Implication of this that as an eyewitness, whether he has named this person. ସେ ଯୋଉ ଘଟଣା ବିଷୟରେ କହିଲା ଘଟଣା ବିଷୟରେ ଏଇ ଯୋଉ ଘଟଣା ସିଏ କହୁଛି ନା ଚିଫ ଏକ୍ସାମିନେସନ PW10 କୁ ପଳେଇ ଆସନ୍ତୁ. I found accused ଇଏ ହଉଛି ଡିଟେନ୍ କରାହେଇଛି ଡିଟେନ୍ କରିଛି ସୁରମୁଲିଆକୁ ଯୋଉଥିରେ ସୁରମୁଲିଆ ଯାଉଥିଲା ଲୁନା ମୋପେଡରେ ଏଇ ସମୟରେ ଆପେଲାଣ୍ଟ ନମ୍ବର 2 ଆଉ ଯୋଉ ଆକ୍ୟୁଟେଡ୍ ଆକ୍ୟୁଜ ସେମାନେ ଆସିକିନି ସ୍କୁଟରରେ ପହଞ୍ଚିଲେ। ଲକ୍ଷ୍ମୀଧର ଆଉ ଓ ଆକ୍ୟୁଜ ସ୍ଥାନୀୟ ସେମାନେ ରାଜଦୂତରେ ଆସିଲେ। ଏଇ ସବୁ ଭେହିକିଲ ଗୁଡାକ ଷ୍ଟାର୍ଟିଂ କଣ୍ଡିସନରେ ଥିଲା। ତାପରେ ଆସଲ୍ଟ ବିଷୟରେ କହୁଛି ଯେ ଦିଘା ମାରଲା ଗୋଟେ ସୋଡ ବ୍ଲୋ, ଦିଘାଟା ଆକ୍ୟୁଟାଲ ହେଇଯାଇଛି ପରେ। ଆଉ ତାପରେ ଡିସିଜ ପଡିଗଲା। ଡିସିଜ ପଡିଗଲା ପରେ ଏଇ ଯୋଉ ଆପେଲାଣ୍ଟ ନମ୍ବର 1 ଲକ୍ଷ୍ମୀଧର ଡେଲ୍ଟ ଏ ଭୁଜାଲି ବ୍ଲୋ, ତାପରେ ତାନିଆ ସେ ଡେଲ୍ଟ ହେଲା ଆଉ ଗୋଟେ ଫାର୍ସା ବ୍ଲୋ ଅନ୍ ଦି ଫେସ୍ ଅଫ ଦି ଡିସିଜ। ତାପରେ ଇଏ ପଳେଇ ଆସିଲା। ତ ଏ ଖାଲି ଘଟଣା ବିଷୟରେ କହୁଛି ବୋଲି ସେ କହୁଛି। ତେଣୁ
Let's see, may I submit one thing?
just a minute.
No, but this witness also did not. What was the statement of that witness to him? What did he say about the occurrence? He said about the occurrence. What did he say?
Say that the
Quote here. That man, quote here. Where from he got this? The only evidence is to the effect in para 9. I know Prasanta Kumar Behra, PW10. He told me about occurrence on the same night of occurrence. Means occurrence, yes, there is a death. Somebody has killed. Who is the assailant? How that the assailant caused the death of the deceased? About. So our question is the authorship.
The chief examination रो जो रहिला paragraph 3 रे एमाने टोटाली केही कहि नादी। तेणु ये सुनिबा ए विषय ज्ञान हवा, it cannot be believed that they themselves have not supported the prosecution case. ସେମାନେ ବି କହୁନାହାନ୍ତି ଯେ ଆମର ଏ ଘଟଣା ବିଷୟରେ କିଛି ଜ୍ଞାନ ଅଛି। ତେଣୁ ସିଏ 3 ଜଣଙ୍କଠୁ ଇଏ ଏ ଘଟଣା ବିଷୟରେ ଜାଣିଥିବ ଏମିତି ଏମିତି ହେଲା। ସିଏ ଆସିଲେ ଏବଂ above witness told me that the deceased was killed by the accused person. They themselves have no knowledge. What is the question of disclosing before this 11?
That is how the trial court has only confined the evidence to PW10. So the question that is before us is again coming back to the question of delay. Whether such delay is in the same manner as the delay has occasioned in Brahmananda Nanda case, or it is different than that?
Because this from the evidence of PW10, at least it does not appear that he left the village. He went somewhere else. Even though he says that he was in fear, but he stays there, and according to him, he disclosed before the family members and villagers.
And the fear is self-imposed.
They have not threatened. She goes you to line for each nago.
PW10 stated that they are not threatened.
No, they are there. And like the other case, here there is no material that these persons or the co-accused persons who are acquitted, they were the hardened criminal, some gangster.
In the other case, it was there.
Political hostility भी थिला कारण आकु accused support କରୁची deceased
support କରୁଥିଲା that the Sonia, then PW11 ପାଖକୁ ପଳେଇ ଆସିଲା। That's why The Schedule 15 also stated that say Sunitila that on the night of the occurrence at about 7 p.m.
Deceased support କରୁଥିଲା PW11.
Yes.
No, deceased, deceased, first,
କହୁଛି ପରା, the deceased Suramali supported me, leaving the accused to amanang. ଆଗରୁ ସେ support କରୁଥିଲା accused କୁ, group change କଲା ନା. For that reason, the accused person had grudge on this one, so for which he was killed on so and so. Accused had arranged one political program, deceased, that was so and so.
After cross-examination again say କହିଛି what all I stated in my evidence in chief was not within my personal knowledge, and I was told by the witnesses above named. Means the three witnesses who have turned hostile are the persons who have informed him besides PW4.
Schedule 15 stated that they are planning, they heard that there is organized for the crime. On the night of occurrence at about 7 p.m., I had been the bridge side of Take Tea. I found that the accused person, namely that Lakhinder Swai, the present petitioner, who accused Digga, who accused Tanya and the two, alias Deepak, were discussing themselves, and they were telling that they will get rid of the situation if the deceased Suramulia and the Yudhishthira Pidul 1 are killed. After hearing that, I left for my work. The Schedule 14, before whom the one of the accused to alias Deepak Mohan disclosed.
क्या पकड़े?
Schedule 14.
Schedule 14. Schedule 14 is
on 1298.
Rabindra Samudraya.
Rabindra Samudraya. I had been through
Did he say Rabindra Samudraya evidence? Told me, Tutu alias Deepak Mohanty told me that he detained the deceased and other accused persons.
Assaulted him.
Assaulted him means to the witness or to Tutu.
Before that, the Suramulia. On being asked me that the matter would not have been a congenital and the deceased Suramulia not been a murder. He also told me that registered out cannot come out his house.
Assaulted him, detained, he detained. ମାନେ deceased କୁ ବି ଅଟକେଇଲା ଏବଂ accused ମାନଙ୍କୁ ଅଟକେଇଲା ହେଲା. he detained ଏବଂ assaulted him. କାହାକୁ assault? ପଢୁନାହାନ୍ତି କି ଆଉ କିଏ?
1298 I had been in Bhubaneswar and on the way at Rasulgarh Chowk I met the accused to alias Deepak Mohan. And the said accused told on being asked by me that the matter would not have been congenital. And the deceased Suramulia not been murdered.
Had the deceased Suramulia not being murdered?
Yes.
He also told me that Yudhishthira Raut cannot come out of his house after the deceased was killed. The accused Tutu alias Deepak Mohan told me that he detained the deceased and other accused person. With the deceased and other accused persons
assaulted.
Se detain kala এবং other accused person তাকে assault kala.
So what does it you mean to say it is a extrajudicial confession or what? Accused Tutu told me that he detained the deceased. That means he means Tutu.
Tutu detained the deceased.
and other accused persons assaulted him.
Oh,
And ମୁଁ ନିଜେ
अच्छा।
କିଛି କରିନି,
ଇଏ ଅଟକେଇଲା ଅନ୍ୟମାନେ ତାକୁ ମାରିଲେ।
ଅନ୍ୟମାନେ ମାରିଲେ।
That evidence of the other witnesses that
But it goes contrary to your that statement which has been given by that PW10. କୁ ଖାଲି ଅଟକେଇଲା, ଅନ୍ୟମାନେ ଯୋଉ ମାରିଲେ ବୋଲି କହୁଛନ୍ତି, ନାଁଟା ହଉଛି ଦୀପକ ନା, ମାନେ ଆକ୍ୟୁଟ। But Tutu has been participate କରିଛି ବୋଲି assault ରେ ଅଛି।
he exculpatory se dela. This confession was exculpatory, but he is saying accused Tutu alias Deepak Mahanti detained the that has corroborated.
ତାପରେ ଦୀପକ
And
ମାରିଛି ବୋଲି କହୁଛି।
Suramalia, who was going in the Luna, the accused Deepak was in a scooter and the co-accused Diga was sitting in Lakshmidhar and also co-accused Tanya were in the Rajput. All the vehicles were starting condition. Co-accused Diga dealt by means of sword on the neck of deceased Suramalia. The deceased fell down on the ground and at that time accused Lakshmidhar dealt brutally blow on the forehead of the deceased. Co-accused Tanya dealt herself. ये कहीं or it this sort of
and PW18 on 20/10/98 at May placement of PW18.
yes, and how did 14
PW18.
18
My lord.
here ना कौन
Krishna Chandra Jena.
ये कौन पहला
On 20/10/98 at about 11 p.m. night on the
Deepavali.
I went to the house of the deceased on hearing of alarm. While going, I found the Pradhan and Ajay Mahanti were sitting on the raspberry motorcycle in front of the house. They told me that the deceased had been killed. I went to the spot and found that
ये Akshay Pradhan and Ajay Mahanti. They told that deceased has been killed. I went to the spot
and found that deceased
is lying with
dead
injury.
with injury.
There was spots such
There are cut in the head and mouth of the deceased.
Who are Akshay Pradhan and Ajay Mahanti के ସେମାନେ hostel ହେଇଛନ୍ତି
Yes, they are hostile.
ସେଥିରେ ଆଉ କିଛି ନାହିଁ
And the cross examination they stated that registered out that PW1 was present in the spot. Similarly, Prashant Vera, that PW10 and other were also present on the night of the occurrence when I went to the spot.
ଯୁଧିଷ୍ଠିର ରାଉତର ପ୍ରେଜେନ୍ସ ଟା ଠିକ ଅଛି ଯଦି ପ୍ରଶାନ୍ତ ବେହେରାର ପ୍ରେଜେନ୍ସ ଟା ଫେର କୁହାଯିବ ତାହେଲେ this will contradict because the evidence of PW4 is that Prashant Behera was present at the spot, which Prashant Behera is saying no because he did not come out thereafter to the spot. ସେ ଯୋଉ ଗଲା ସାଇକେଲ ଫୋପାଡ଼ିକି ଘରକୁ ସେ ଆଉ ସ୍ପଟ କୁ ଆସିନି ବୋଲି କହୁଛି କିନ୍ତୁ PW4 କହିଲା ଯେ ଯେତେବେଳେ ମୁଁ ଆସିଲି ସେତେବେଳେ ପ୍ରଶାନ୍ତ ବେହେରା ଥିଲା ଯୁଧିଷ୍ଠିର ଥିଲେ ମୁଁ ପଚାରିଲି କେମିତି କିଏ ମାରିଲା ସେମାନେ ଇଗ୍ନୋର ସୋ କଲେ So how do you
and my lord, I will bring to my lordship, my lord, the PW10 is in the present in the occurrence. PW10 was present
at the scene of occurrence. He was present at the scene of occurrence.
But they are stating that I seen and
went away
by throwing the cycle.
Achha.
ସେ out of fear ର ସେ କଥାଟା କହୁଛି ମୁଁ ପକେଇ ଦେଇ ପଳେଇଲି।
So that is your case. Now, keeping in view the evidence that he was a person who was present in the
And
scene of occurrence.
Yudhishthira Raut ମଧ୍ୟ PW 11 also say that ପ୍ରଶାନ୍ତ ବେହେରା ମଧ୍ୟ ଥିଲା ବୋଲି।
Oh.
and ସେଥିପାଇଁ ସେ ଯୋଉ ତା କ୍ରସ କହୁଛେ out of fear
ମୁଁ ପଳେଇଲି।
but I did not face the police out of fear.
Oh, it is not that he was witnessing the incident at a distance of 10 to 12
and
feet. No, he was very much present.
And he also disclosed before the Yudhishthira that Yudhishthira ଆଗରେ କହିଛି ମତେ Yudhishthira that is the evidence of the PW 11 Yudhishthira କହୁଛେ ମତେ ମୋ ଆଗରେ disclose କରିଛି PW 11 stated that paragraph 9 I had seen Tapos Mulia, that is the son of the PW 4 son of the deceased of the same night of the occurrence at the spot. Yudhishthira.
Oh, yes.
I know Prashant Kumar Behra, PW 10.
He was also present.
He told me about the occurrence on the same night of occurrence. ସେ ସେଠି ପ୍ରେଜେଣ୍ଟ ଥିଲା ଏବଂ ସେ ମଧ୍ୟ ଆକୁ କହିଛି ଯେ ଅକରାଂଶ ଏଇଆ ମୁଁ ଦେଖିଛି ବୋଲି।
But about the names, he has not.
The name.
কারণ PW4 evidence has been rightly pointed out. এটাକୁ ଆପଣ 4 is not a witness who has been declared hostile. And they have brought out that he was asked and they expressed ignorance who killed the father. So
appreciation is one part, but could you mark this thing after thorough examination how the evidence is coming? Appreciation is one part. 4 thila ki nahi, 10 thila ki nahi, 11 could have been there or not. But unless you go between the line in the evidence, he could not have. The link that now you are trying to bring, again we say that yes, the thila ki nathila are all appreciation.
And also, my lord, in the evidence of the accused C13, they are not saying anything about symptoms.
Why they would say?
Why they would?
They are right to keep mom particularly. Is it a case of right of private defense that they would plead something, put specific suggestion to the witnesses regarding such plea, and also prove something? If they have pleaded denial, they are phase of one of denial.
Except that the accused have special means of knowledge. Otherwise, you cannot insist for 330.
And your case is also that there was political rivalry. As Mr. Naik is pointing out, that is also borne out of the record because they changed the side. That is how something.
And they also discussed that is stated by the PW 14 and 15 to planning to the murder. The evidence of the doctor is also corroborated.
About conspiracy.
Conspiracy. କଲେ ଯେ ମୋ ଆଗରେ କହୁଥିଲା ମାନେ 2 ବାର ଅର୍ଥ ଲାଗୁ that incident was the month of October, ଡିସେମ୍ବର ମାସରେ ସେ ରସୁଲଗଡ଼ ଛକରେ ଦେଖା ହେଲା ଏବଂ that ପିଟୁ ଆଲିଆସ୍ ଦୀପକ ମହାନ୍ତି କହିଲା ଯେ ଏୟା ହେଇଛି।
तो ये एग्जामिन के पहला PW 14
but after 44 days.
So that means after this ये अच्छा 2 बार पर ही ये केबे अरेस्ट हला टुटू
ତା ପରଦିନ କହିଲା
माने ए 2/12/98 परदिन
ନାଇଁ ପରଦିନ ସେ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କଲା ପରେ ପୋଲିସ ଆଇଓ ତାକୁ ଏକ୍ସାମିନ କଲେ
ए विटनेस को हां तापरे ताको अरेस्ट
ପରେ ପରେ arrest
और तापरे अरेस्ट
এটা কাজে কলেক্ট করলে 40 সেকেন্ড নেই তখন থাকবে যে arrest
ତ ତାପରେ ଟିକେ କରୁଛନ୍ତି ଆଉ ଏକ୍ଜାକ୍ଟଲି ନାହିଁ କାହିଁକି ବି ଆରେଷ୍ଟ ମାଳିକିଟା କହୁଛନ୍ତି ପରେ ଷ୍ଟେଟମେଣ୍ଟ ଦେଇଛି ଆରେଷ୍ଟ
ଆରେଷ୍ଟ ଡେଟଟା ନାହିଁ କିନ୍ତୁ ତାପରେ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ପକଲା 42 ଦିନ ପରେ
ଏ ଯୋଉ 66 ପେଜର 46 ପେଜ
बालकृष्ण स्वाइन that decision was the 3 judges bench 2017 SCC 549. In that decision, my lord,
ବାଳକୃଷ୍ଣ ଭାଇ ଏକସ୍ତରୀ ତ ଏକସ୍ତରୀ ଆମର ଅଛି
କୋଉ ପାରାଗ୍ରାଫ
my lord, Paragraph 6 that Mr. Rajkumar Gupta, learned advocate, appearing for the appellant, invited the attention of the testimony of the two eyewitnesses, namely of the 1819 submitted that the delay in recording their statement under section 162 and 164 of this CRPC respectively would be fatal to the case of the prosecution. It was submitted and no expansion was pursued. There was a delay in recording the statement. Reliance was placed with decision of the Balakrishna Swami, state of Odisha. It was further submitted that apart from the testimony of the said two witnesses, there was nothing on record to justify the conviction of the appellant. Mr. Lisa Mathis, an advocate, appellant state, on the other hand, submitted that the terror unleashed by the accused was the such magnitude that the witness concerned had fled away in the fear, and that it was only after the appropriate steps were taken by the investigation machinery, including the arrest of the accused, that the witness. Mr. Mathis also submitted. Paragraph 10, it is true that there was some delay in the recording of the statement of the eyewitness concerned, but the mere fact of the delay by itself cannot result in the rejection of the testimony. The matter on record definitely established the fear felt by the accused if the witness felt terror and fatigued and did not come forward for some time. The delay recording their statements to the placement, nothing has been brought on record to the sort that during the interview, the witness were carrying on their ordinary pursuit. Thus, the eyewitness cannot uphold, so the PM reckoning cannot be discarded. And that decision also, another 3 judges benches.
ନାଇଁ ଏଠି ସେମାନେ ଆରେଷ୍ଟ ହେଲା ପରେ ହିଁ ଷ୍ଟେଟମେଣ୍ଟ ଦେଇଥିଲେ paragraph number 8 ରେ କହୁଛି it was only after the appropriate steps were taken
by the
investigating machinery, including the arrest of the accused, that the witness came forward. ତାପରେ nothing has been brought on record to suggest that during interregnum the witnesses were carrying on their ordinary pursuits. ତେଣୁ ପ୍ରାୟ ସେମାନେ ମାନେ ଟେରର ଥିଲା ସେଠି ଲୁଚିକିନି ରହିଥିଲେ ଫ୍ଲେଡ୍ ଆୱେ ଆଉ ଆକ୍ୟୁଜ୍ କୁ ଯେତେବେଳେ ଆରେଷ୍ଟ କରାଗଲା ତାପରେ ସେମାନେ ବାହାରିକିନି ଆସିକିନି ଏଇଟା ଏଇ କେସର ହାଉ ଡୁ ୟୁ ସେ ଦ୍ୟାଟ୍ ଏଠି ତ ଗାଁରେ ଅଛନ୍ତି ଏଠି ତ ତାଙ୍କର ଫ୍ୟାମିଲିକୁ ସାଙ୍ଗରେ ସେ କହୁଛନ୍ତି ଆମେ କଣ୍ଟାକ୍ଟରେ ଥିଲୁ କୋ ଭିଲେଜର୍ସଙ୍କ କଣ୍ଟାକ୍ଟରେ ଥିଲୁ and by the time the statement was given
that out of fear we cannot say that so far the eyewitness is concerned, they cannot say that out of fear, but in fact
no, the accused persons were not arrested when they gave the statement. Whether all the accused persons were arrested? No.
That is what our query was then. How that the fear dispersed on the day
accused ମାନେ arrest ହେଇନଥିଲେ ପର୍ଯ୍ୟନ୍ତ
ନା accused ତ arrest ହେଇଛନ୍ତି ଡିସେମ୍ବର
ହଁ ଆପଣଙ୍କର ଇଏ ମଧ୍ୟ statement ର timing ଦେଖନ୍ତୁ ଆଉ date of time of arrest ଦେଖନ୍ତୁ. They were not arrested by the time he gave the statement. ତାର 161 ଟା ଉପରେ କେବେ ବାହାର କଲେ ଯୋଉ ଇଏର ୟା ନାଁଟା କଣ PW10 ର ନାଁଟା
ପ୍ରଶାନ୍ତ କୁମାର ବେହେରା
ପ୍ରଶାନ୍ତ ବେହେରା କେସ୍ ଡାଏରୀଟା ବାହାର କଲେ ଟିକେ
21/10/98
ପ୍ରଶାନ୍ତ ବେହେରା ଦେଖୁଛୁ ଆମେ ପ୍ରଶାନ୍ତ ବେହେରା ଏକ୍ସାମିନ ହେଲା କେବେ
ଇଏ ହେଲା 21/10
ଏବଂ ଲକ୍ଷ୍ମୀଧର ବି
ଭୋର 3ଟା ବେଳେ ଭୋର 3ଟାରେ in the wee hour 12:30 ବୋଧେ 00.30 AM ଅଛି ନାଇଁ 8 AM କି 9 8 AM 8 AM
8 AM
ପ୍ରଶାନ୍ତ
ସେତେବେଳୁ କୌଣସି ଆକ୍ୟୁଜ୍ଡ ଆରେଷ୍ଟ ହେଇନଥିଲେ କାରଣ ପ୍ରଥମ ଆକ୍ୟୁଜ୍ଡ ଆରେଷ୍ଟ ହେଲା ତାପରେ ଦେଖନ୍ତୁ
21/10/98 ଲକ୍ଷ୍ମୀଧର ପାଇଁ ଆରେଷ୍ଟ 21/10/98
on the very day
11:30 ରେ ଆରେଷ୍ଟ ହେଲା ରାତିରେ
maybe after the examination of this
ଗୋଟିଏ ମାତ୍ର ତାପରେ ଅନ୍ୟ ଆକ୍ୟୁଜ୍ଡ ମାନେ ପରେ ଆରେଷ୍ଟ ହେଇଛନ୍ତି
that accused ସୁଭାଷ ଚନ୍ଦ୍ର ରାଉତ arrest 21/10
अच्छा
सुभाष
Yes.
जस्ट लक्ष्मीधर सुमांशु सन ऑफ सुमांशु अच्छा हाँ दी जन आरे राइट सो PW10 statement recorded on କୋଉ ତାରିଖ 21/10/98 at 8 AM ମାନେ ଦିନ ସକାଳ 8টাରେ ଆଚ୍ଛା ଦି ଜଣ accused କିଏ ଆରେଷ୍ଟ ହେଲେ ଲକ୍ଷ୍ମୀଧର ମାନେ ଆପଲାଣ୍ଟ ନମ୍ବର 1 ଆଉ ଗୋଟେ କିଏ ଆରେଷ୍ଟ ହେଲା ସୁବାସ and Subhas arrested on 21/10/98 at 11:30 ରାତି 11:30 ରେ ଆରେଷ୍ଟ ହେଲେ କେସ୍ ଡାଏରୀ ଯାହା ଦେଖୁଛି ଆଉ ବାକି ସେ ଦି ଜଣ ରହିଛନ୍ତି ମାନେ ସେ ଦି ଜଣ ଆରେଷ୍ଟ ହେଇନାହାନ୍ତି ସେ ଦି ଜଣ କହୁଛନ୍ତି ପୁରା କଣ ଡିସେମ୍ବର ଆରେଷ୍ଟ ହେଲେ ନା କଣ
ଜଣେ 5/11 ଜଣେ 31/10/98 ଅକ୍ଷୟ ସ୍ୱାଇଁ 31/10/98 ଆରେଷ୍ଟ
31/10/98 ଦେଖିର
ମାନେ ଦୀପକ ତ ଆରେଷ୍ଟ ହେଇଛି ପୂର୍ବରୁ ବିଫୋର ଏକ୍ସାମିନେସନ ଅଫ ଦିସ୍ वन
31/10 ରେ ଆରେଷ୍ଟ ହେଲା ଅକ୍ଷୟ ଆଉ ଗୋଟେ ପୁରା 4 ଜଣ ତ ଟୋଟାଲ ସ୍କୁଟରରେ 2 ଜଣ ମୋଟରସାଇକେଲ 2 ଜଣ ନା 4 ଜଣ ये 3टा ହେଇଗଲା ଆଉ ଗୋଟେ କିଏ ରହିଗଲା
विजय दीपक एलियास टुटू और दीघा अच्छा they had
सब ଦି ଜଣ abscond ଦି ଜଣ ଥିଲେ
Tutu was having several people
ये केसटा जोटा आपण प्लेस कले जोटा सेकंड रे गौतम आदिरे जना पड़ुची जे आज सेमाने पूरा एकदम ऑर्डिनरी परसुट भी अटेंड कर नथिले जो दीटा विटनेस भୟରେ ସେମାନେ ଲୁଚିକିନି ଥିଲା ଭଳିଆ ଥିଲେ ଆଉ ଯୋଉ ମୁହୂର୍ତ୍ତରେ ଆକ୍ୟୁଜ ମାନେ ଆରେଷ୍ଟ ହେଇଗଲେ ସେ ଜାଣିଲା ପରେ ସେମାନେ ବାହାରିକିନି ଆସିକିନି statement ଦେଇଛନ୍ତି ଏଇ ଯୋଉ କେସଟା ଆପଣ that is why it is mentioned that nothing has been brought on record to suggest that during the interregnum the witnesses were carrying on their ordinary pursuits and they fled away in fear and it was only after the steps were taken by the investigating agency in the arrest of this one so that the witness came to them. So that is the thing there. How
And
come
that the courtrooms of that case also, they had upon another three judges benches also. But there is stating that there is no hard and fast rule for the Firoz Khan Matwar.
ନା ଏଇଟା ତ ଜେନେରାଲ ଜିନିଷ ଆମେ ସେଟା ତ ଆପଣ କହୁଥିଲୁ
ହୁଁ।
ମାନେ ଡିଲେ ହେଇଗଲା ମାନେ ନୁହେଁ ଯେ ଆପଣ ଇଏ କରିଦେବେ ସେଇଥିପାଇଁ ତ ଆପଣ ଆମେ ଆମେ
ଦେଲୁ, opportunity ଦେଲୁ।
satisfactory explanation କୁହାହଉଛି ଯୋଉଠି ବି and we gave you an example that a case where that lady was examined 7 days after and that's a death reference case कि अटकी ताकू रखिले ताकू माने गाँ रे पूरा ये करी से खसी दिन आसीकिन तापर एफआईआर देला so 7 days delay ତେଣୁ it depends upon the case to case basis ତେଣୁ here just ଖାଲି ଗୋଟେ visualize କରନ୍ତୁ ସେ ଲୋକଟା ସେଇ ଗାଁରେ ଉପସ୍ଥିତ ଥିଲା ତା ଫ୍ୟାମିଲି ସହିତ ଥିଲା ଗାଁ ଲୋକଙ୍କ ମଧ୍ୟ ଦେଖା କରୁଛି पुलिस ऑलरेडी आसीगलानी पुलिस इन्वेस्टिगेशन जारी रही पुलिस तार से विटनेसेस मानक एग्जामिन करूची आउ से पर्यंत सी स्टेटमेंट दवा पर्यंत कोनोसी अक्यूज अरेस्ट ही ना ई सिचुएशन को नेकिनी सी आसीकिनी 1.5 दिन डिले एठी एप्रिसिएशन रो एटा रोज बाकी को केस रे कोन हेतियो फैक्चुअल सिनेरियो he is that type of witness we have already stated that yaha je ki jane sakhi कहूची जे घटना परे ताके पचारला बेलू सी मना कला कला मु जाने आउ फैमिली मेंबर्स माने कि एग्जामिन ही ना विलेजर्स मानक भितर गोटे एग्जामिन आपण करचंदी 11 नंबर सखी से कहूची मते घटना विषय रे कहला नॉट दैट ये आ जहां को टू से 11 नंबर सुनीची से साखी माने सपोर्ट कलेनी year and after of course we have rejected it that subsequently kala मोर घटना विषय किसी धारणा नाही तेणु that is your star witness
out of pure psychosis, they are not disclosed that immediately they are not disclosed for the IO.
No, as my esteemed brother pointed out how that pure psychosis dispersed अरे ସେତେବେଳେ ତ ତାକୁ କେହି ଧମକ ଚମକ ଦେଇ ନଥିଲେ ସେ ତାର ଏଇଟା ସ୍ୱତଃପ୍ରବୃତ୍ତ ଭାବରେ ଭୟରେ ଆସିଗଲା ଯଦି ଭୟଟା ଥିଲା ଭୟରେ ଥିବା ସତ୍ତ୍ୱେ ମଧ୍ୟ ଯଦି ଏତେ ଲୋକଙ୍କୁ ଡିସକ୍ଲୋଜ କରୁଛି ପୋଲିସ ଆସିଗଲାଣି ତାପରେ ସେଟା ଆକ୍ୟୁଜ ତ ଆରେଷ୍ଟ ହେଇନାହାନ୍ତି ନା ତ ସେ ଭୟଟା କେମିତି ଚାଲିଗଲା କେମିତି ହଠାତ୍ ଗୋଟେ 1.5 ଦିନ ପରେ ପଳେଇ ଆସିଲା ସେ ତ ଆଗରୁ କହିପାରିଥାନ୍ତା ଅନ୍ୟମାନଙ୍କୁ ପୋଲିସ ନଜରରେ ବି ନାହିଁ ଯେ କିଏ ଆକ୍ଚୁଆଲି ଇଏ କରିଛି ବା ସେଟା ହଉଛି କଥା these are all appreciation of the thing the decision just ଗୋଟେ more supporting decision but it all depends upon the fact of different cases से जो ब्रह्मानंद केस रे कौन कहले हार्ड एंड क्रिमिनल हेतिबो मनकर एठी गोटे सेई टाइप रो क्रिमिनल जाना प्राय केस थिबो ताकू जने देखिबो क्राइम टे करूची तो आगे निजे चिंता करी मको डिस्क्लोज करिवि ता ना ताले साक्षी देबी ताले मो परिवार कथा कोन हो काल सकाळे मो ऊपर भी अटैक हे तो भयटा रहिबो तेणु
ଏଠି ଭୟଟା ଆସୁଛି କାହିଁକିନା ବିକଜ ଅଫ୍ ପୂର୍ବରୁ ସେ ତାଙ୍କ ସହିତ ଥିଲା ତାପରେ ଯେତେବେଳେ ଆଙ୍କ ପାଖକୁ ଆସିଗଲା ପଲିଟିକାଲି ସେ ଫର ଦ ଟାଇମିଂ ହି ଥଟ୍ ଦ୍ୟାଟ୍ ଯଦି ମୁଁ କହୁଛି ତାହେଲେ ଆଇ ୱିଲ୍ ପୁଟ୍ ଇନ୍ ପ୍ରୋବ୍ଲେମ ଦ୍ୟାଟ୍ସ ହ୍ୱାଇ କିଛି ଜଣ ସାକ୍ଷୀ କହି ସାରିଲା ପରେ then they disclose for the
how many cases of that particular gangster has been acquitted? You know that too. Nobody is coming forward. So that happens. They must have given the statement before the police. Now see in the witness in the
से जो even PW4 तार 164 रे भी ये कहूला मोर बापांकर ब्लॉक रु 80,000 टंका पाइबार थिला सेही दिन सेथि पे बापा युधिष्ठिर राउत घर को जाइथिले बापा मरिगला परे मु एही टंका कथा जाई युधिष्ठिर राउत को पचारली से मते आजिकाली कही 5 मास दौड़ाइले तापरे कहले तोर बापा एडवांस 30,000 नहीं काम करितिला सब टंका तोर बापार मर्डर केस रे खर्च होईची मते एतलार स्टेटमेंट रो कॉपी देखाइले समस्त स्टेटमेंट पढ़िया परे मोर प्रशांत बेहरा उपरे संदेह हैला कारण से प्रथम रु शेष पर्यंत मो पाखे थिला किंतु स्टेटमेंट कहिछि जे से किछि देखि ना मोर संदेह होछि से युधिष्ठिर राउत रे प्रशांत बेहरा मोर बापांकर पैसा खाई चक्रांत करी मोर बापा को मर्डर करथि एठी से आ गोटे कथा कहले
କିନ୍ତୁ ପ୍ରଶାନ୍ତ ଏଇ ଯୋଉ PW10 କୁ ମିଟ୍ କରିବା କଥା ସେ କହୁଛି ଏବଂ ତା ପାଖରେ PW10 କିଛି କହିନି ବୋଲି ସେ ମଧ୍ୟ ସେ ଷ୍ଟେଟମେଣ୍ଟରେ କହୁଛି ବଟ୍ ସେ କହୁଛି ମୁଁ ଭାବୁଛି ସେ ମୋତେ ମିଛ କହୁଛି ଯୋଉ ଆଇ ୱିଟନେସ୍ ମିଛ କହୁଛି
ଏଇଠି ସେଇଟା ସେଇ କଥା ସେ କହୁଛି ମୁଁ ଯୁଧିଷ୍ଠିର ରାଉତରାୟ ପ୍ରଶାନ୍ତ ବେହେରାଙ୍କୁ ମୋ ବାପାଙ୍କୁ କିଏ ମର୍ଡର କରିଛି ପଚାରିବାରେ ସେମାନେ ଜାଣିନାହାନ୍ତି ବୋଲି କହିଲେ ଆଉ ମତେ ସେଇଠାରେ ଏଫଆଇଆର ଲେଖିବାକୁ କହିଲେ
ପ୍ରଶାନ୍ତ ଇଜ PW10
ତାଙ୍କର ଯେଉଁମାନେ ପଲିଟିକାଲ ଶତ୍ରୁ ସେମାନଙ୍କ ନାଁ ମତେ ଲେଖିବାକୁ This is 164 of PW4. कंसिस्टेंसी थाई ये जो conspiracy रा जो evidence का आनी चंदी probably it could have helped you provided there could be some consistency in the evidence of PW10. It would have definitely helped. ये जो examination जोटा extra judicial confession कथा कुहाउची with regard to PW14. PW14 has also been earlier examined by the police. And during that time, he had only stated about the conspiracy. But later in the month of December, that is 2nd of December, he has been examined again. And that time he is disclosing that on that particular day he stated, confessed. Several round of examination is also there. युधिष्ठिर को आउथरे जो आउथरे केबे एग्जामिन हला देखनांती से प्रथम थर एग्जामिन हिची कन्स्पिरेसी कथा से कहि की
मना रद्द सम
छाड़ दी गई
तीन बार बोले
मंत्र ना लिखियो से किसी को 160 करोड़ कुछ नहीं
ऐसे सुरे में देखिए हॉस्पिटल पर है ना मिनट कॉस्ट ये सब ठीक
Rule 15 is 11. Register and person set 11.
Regard to the non-seizure of psychology effect. If he said to be in the court and he left this writing and whatever it is go, then police has reached the same evening and has seized settlement there.
But not see the site.
Seizure of this act. That is not.
And that the pure psychosis, my lord, that
Okay.
subsequently evidence in the another case, ST case. That's the so Kauchi acquittal agency. I knew the deceased Surunamilia who died about 4 years back. I do not know anything about the case. I was examined by the police in connection with the death of this Surunamilia. At this stage, London PP files petition declared hostile.
Right.
Till that was examined on 3rd day of February 2003. First in the another same case रे से कहूची मु ये एवढा देखिली. But
Then how can you presume?
that the pure psychosis.
Why was the clear? Why was that clear? Consist till 6 to 7. Because consisting according to you, that is how it did not die was the subsequent. Though this stated in this case, it did not state this in
Another cases.
So according to you, this fear was still persistent. By then they have already been arrested. By then they have already been arrested. And one has already been convicted.
To convicted to acquittal and to absconded. Absconded कहूची एवढा.
So, but what is there on record? What you presume it might be correct, but you have to clear it from the record. Because of their antecedents, they were of different kind of persons. Antecedents, police were anything kind of. Anything. They were anything else of. Later, circumstances go clearly.
Clear that ଯେମିତି ସିଏ ତାର ଘଟଣାଟା ଦେଖିଦେଲା ସେ ଚୁପଚାପ ପଳେଇଲା ସାଇକେଲଟାକୁ ଛାଡି ଦେଇକି ତାକୁ ବି ଏମାନେ ଦେଖିଛନ୍ତି ଆପଲାଣ୍ଟ ଦେଖିଛନ୍ତି ବୋଲି ବି କିଛି ଏଭିଡେନ୍ସ ନାହିଁ ସେ ତା ମନ ସେମାନେ ତାକୁ ଦେଖିନାହାନ୍ତି ଇଏ ଘଟଣା ଦେଖିଛି ବୋଲି ଆଙ୍କ ଜ୍ଞାନ ବି ନାହିଁ ନହେଲେ ମାନେ ଆପଲାଣ୍ଟ ମାନ ହେଲା ସିଏ ତାର ମନକୁ ମନ ଭୟ ହେଇଗଲା ଭୟଭୀତ ହେଇକି ପଳେଇଲା ଭୟଭୀତ ହେଇକି ପଳେଇ ଆସିଲା ତା ନିଜ ଘରକୁ ଆସିଲା ଗାଁ ଲୋକଙ୍କ ସାଙ୍ଗରେ ମିଶୁଛି ଏବଂ ପୋଲିସ ବି ଚାଲି ଆସିଛି ତ ସେଠି ଯଦି ତାର ଭୟ ରହୁଛି ତାପରେ ପୁଣି ହଠାତ୍ ଭୟଟା କେମିତି ପଳେଇଗଲା କ୍ଲୋଜ କରିଦବା ଦେଖିବ ଆଉ କିଛି କହିବେ କି ମିଷ୍ଟର ନାୟକ ଆପଣ କିଛି କହିବେ କି
PW11 suggested that PW10 told me about the occurrence. The PW10 on his statement in page 66, PW10 himself told on 20th I met Yudhishthira Rautrai. I did not venture to tell him about the occurrence.
Yes, that's all.
କୋଉ ଲାଇନ୍ ଟା କହୁଛନ୍ତି ଆଉ ଟିକେ
Para page 66, para 17. Last line. On 20/10/98, I met Yudhishthira Rautrai. I did not venture to tell him about the occurrence.
ସେ କନସିଷ୍ଟେନ୍ସି
ଯୋଉଟା କିଏ କି ଯୁଧିଷ୍ଠିର ରାଉତରାୟ
ମତେ ସେ କହିଲା ସେଇ ଦିନ ରାତିରେ
ଏଟା ହଉଛି ତା ମାନେ it contradicts the version of PW11
Yes. PW11 also told that there is no cycle also. I did not
leave that cycle theory. We are on other things. So look at this. How the Mr. Dharmadan Naik, consumer advocate, and this is now the unit of what is your full name and counsel?
Akash Bhuya.
AKASH Bhuya for the appellants and Mr. Jefferson Naik, medicine government advocate. You will do judgment results.
I have my power at your matter. My power is there.
ଆଉ ଆପଣଙ୍କ ଭୋକାଲତନାମା ଆମେ
ପାୱାର ଅଛି ଯେତେବେଳେ ଦେଇଥିଲି ଭୋକାଲତନାମା
ଠିକ ଅଛି
In fact, I am weak in the criminal. In fact, I am weak in the criminal. Apart from that, what I learned in the about 6 to 7 months.
No, that is how you have to be very particular. You see, you have been able to bring on record certain things which we had to ponder upon, and that is what is required. And unless you come out with the cases, how can you? If a little more effort would have been taken, probably things would have been much better.
You see, somebody if he has inclination, he can learn about a particular branch of law. It is not that it is impossible. So even if you say that I had practice in criminal law, that doesn't mean that you cannot, because you are in this bench, you are attached to this bench, and
that's why we learn something in this
passage of time. You are getting experience how we are approaching the case, and particularly this hearing matter. It's not the bail matter. So how the court is approaching the bail matter, what sort of questions are being asked, and how the appellant's counsel is raising the point. So once you analyze all these things by passage of time, you will get experience. That is how the thing goes on.
But this is not expected that you will learn at this stage when the matter
that's
is.
important. Another side, my senior is there, so in that way,
No, senior is there.
Which is the other matter we reserve the judgment? Sorry,
no, 16 is there.
No.
How would you put it?
20.
Yes, please.
Last one, Lord.
Have you given a copy of the written note to the State Council?
Written note, I have filed the judgment.
No, judgment.
Yes, yes.
Well, sorry, right?
Yes, my lord. Last time you were asked some judgment, my lord.
Citation.
No, about that 302.
Yes, my lord. 302.
What you have found out, let us see.
Paragraph 8, my lord. After going to
Because the
relying
dead body has been
disposed
disposed
of.
of.
Yes, my lord.
And the deceased was with you
Yes, my lord.
when she died.
Yes.
So, in absence of the post-mortem report, because of the disposal of the dead body, how the court will come to a finding that it is a homicidal death? Why not that he has met or she has met a unnatural death for which the dead body was disposed of?
Paragraph 8.
Partner. Yes.
Partner, after relying the appeals court judgment, my lord, that order has been passed in 2003, my lord. 23, my lord. Paragraph 18, 13.
Paragraph number 18.
Yes, my page 13, my lord.
Hold on.
We have gone through the deposition given by the prosecution witnesses and the other material placed on record, from which it transmits that there is no eyewitnesses to the incident in question. Nothing has come on record as to how the deceased died, whether because of the burn injury or the protein. The dead body of the deceased was disposed of, and the post-mortem of the dead body was not conducted, with a view to prove the case against the accused. The prosecution had examined 3 near relatives of the deceased, that is the PW1 mother, PW4 father, PW6 the brother of the deceased. The prosecution has also examined 4 independent witnesses who are neighbor of the deceased. From the deposition of the prosecution witnesses, it will emerge that the near relative of the deceased have for the first time stated before the court about the demand of a dowry rupees 20,000 by law of the deceased. The said aspect has been admitted by the investigation officer during his cross-examination. It is pertinent to note at this stage that except appellant, who is the husband of the deceased, all the other accused who are near relative of the appellant have been acquitted by the trial court. It is pertinent to note that the similar type of allegations are leveled against all the accused by the relatives of the deceased, that is PW1, PW4, and PW6. In spite of that, the trial court has not believed the story of the said witnesses, so far as the other co-accused are concerned. It is also required to be noted that initially the FIR came to be registered under section 302 and 201 of the IPC. However, before the trial court, charge was framed under section 304B and 201 of the IPC. From the impugnment order passed by the trial court, it is transmitted that the trial court has not believed the story of the prosecution with regard to the demand of a dowry, and therefore all the accused have been acquitted. So far as the offence punishable under section 304B 492 of the IPC is concerned, the present appellant has been convicted for the offence punishable under section 302 lead with the section 201 of the IPC, only relying upon section 106 of the Evidence Act 1872. In the appropriate background of the present case, at this stage, we would like to refer the provision contained in section 106 of the Evidence Act 1872, which provides as under. Burden of a proving fact is still within knowledge. When any fact is still within the fact is upon him. 19.1. From the appropriate provision, it is revealed that when any fact is still within the knowledge of any person, that the burden of providing that fact is upon him. It has been observed by the trial court that when the death of the deceased has been taken place at the house of the appellant, in which the appellant and his wife, that is the deceased, were residing, and when the said house is the ownership of the appellant, it was the duty of the appellant to discharge the burden under Section 106 of the Indian Evidence Act. That it was for the appellant to disclose before the court the manner in which the incident took place, and the deceased died, and therefore on this ground the appellant has been convicted. At this stage, we would like to refer the decision rendered by the Honorable Supreme Court in case of Renza Hazarika versus State of Assam reported in 2019-13 ECC 289, wherein the Honorable Supreme Court has observed in paragraph 9 as under the essential of substantial evidence stand as well established by the precedent, and we do not consider it necessary to reiterate the same and burden of the other unnecessary. So far, it is observed that in the case of substantial evidence, the links of the chain of the circumstances so as to lead to the only and incapable conclusion of the accused being the assailant, inconsistent and incompatible with the possibility of any other hypothesis compatible with the innocence of the accused. Mere invocation of the last in theory, since the fact and evidence in the case will not suffer to shift the onus upon the accused under Section 106 of the Evidence Act unless the prosecution first establish a prima facie case. If the links of the chain is itself are not complete and the prosecution is unable to establish a prima facie case, leaving open the possibility that the occurrence may have taken place in some other manner, the onus will not shift to the accused and the benefit of doubt will have to be given. In the case of Shambhunath Meher versus the state of Ajmer reported in AR 1956 Supreme Court 404, the Honorable Supreme Court has observed that Section 106 of the Evidence Act is not substantive for the burden of the proof that the rest upon the prosecution. Thus, from the aforesaid decision, it can be said that a criminal trial, the burden is always on the prosecutor to prove the guilty of the accused beyond a reasonable doubt, and Section 106 of the Evidence Act is not intended to the relief the prosecution of its burden. Further, only when the can be drawn regarding certain other facts which, unless explained by the accused by virtue of his special knowledge, tend to inculpate the accused. In such circumstances, the accused owed as explanation. Otherwise, the Section 106 of the Evidence Act does not put any burden on the accused to prove his innocence. Keeping in view the aforesaid observation made by the Honorable Supreme Court and the provision contained in Section 106 of the Evidence Act, if the facts of the present case as discussed herein above, it is revealed that the prosecution has failed to discharge its burden, and therefore the reliance placed by the Law Trial Court upon Section 106 of the evidence is misplaced. At this stage, it is also relevant to note that there are 4 independent prosecution witnesses who are neighbors of the deceased, have especially stated while giving the deposition before the court that there was no demand of a dowry by the in-laws of the deceased, and the deceased was having good relation with her husband and her in-law. They have also stated that the deceased was hard hearing and mentally challenged, and her in-law have not killed her. Thus, from the deposition of the independent prosecution witness, it can be said that the prosecution has failed to prove the case against the accused beyond a reasonable doubt, and therefore also reliance placed by the trial court on Section 106 of the Evidence Act is not tenable. From the impugnant order passed by the Law Trial Court, it is further revealed that the trial court has not believed the story put forth by the prosecution to the other accused except the appellant, and therefore the trial court has acquitted all the near relatives of the present appellant and the in-laws of the deceased. However, surprised the trial court has relied upon the deposition of the said witness while passing an order of the conviction against the appellant. In view of the aforesaid discussion, we are of the view that the trial court has committed an error while recording the order of conviction against the present appellant, and therefore the impugnated order is required to be quashed and set aside. The impugnated judgment of the conviction dated so and order of sentence passed by the law and presiding officer fast track court Nalanda of Bihar.
How is it applicable to this case?
ଏ କେସ୍ ଆପ୍ଲିକେବୁଲ କେମିତି ହବ?
ଯେମିତି
ସେ କେସରେ ଆପଣଙ୍କର 304B
302 ଦିଆ
DPR ଏଗୁଡାକ ସବୁ ଆକ୍ୟୁଟାଲ ହେଇଯାଇଥିଲା, ଅନ୍ୟ ଟୁ ଆକ୍ୟୁଜ ମାନେ ଆକ୍ୟୁଟାଲ ହେଇଯାଇଥିଲେ। ଏଠି ତ ସମସ୍ତଙ୍କୁ ଏକ୍ସେପ୍ଟ 201 ଛଡା ଅନ୍ୟ ସମସ୍ତଙ୍କୁ କନଭିକ୍ସନ ହେଇଛି ଏବଂ 304B4 DPR that has
In
been
this case,
302 has been charged here. ସେଠି charge ହେଇନି.
ଚାର୍ଜ ହେଇନଥିଲା।
There the only case is 106. Here it is 304B coupled with 106. Their neighbors have come deposing the conduct of the party. Here it is not there. Here it is a consistent case of cruelty. How you are applying that? Pradhan, anything you have brought?
I know. This one.
No.
Para 17 and 18. Para 17 and 18.
17 and 18.
May I read it?
In
the present case, the prosecution proved that the death of Santosh has occurred otherwise than under normal circumstances. Such death has occurred within a period of 9 months of her marriage, that is much before 7 years. The statement of PW2 and 3 are trustworthy, and they stated that Santosh Kumar was subjected to harassment by her husband and other accused relatives in connection with demand for dowry just prior to death. The prosecution having established essential ingredients, it becomes the duty of the court to raise presumption that the accused caused dowry death. In the present case, the accused has failed to explain as to why he was in a hurry to cremate the deceased in the early morning of 24th January 1993, while she died. While she died in the midnight of 23rd or 24th January 1993, that is within few hours. The village of deceased parents were just 17 to 18 kilometers far from the village of the accused. But the reason as to why they were not informed about the incident on the same day and why the accused had waited for them to come is not explained. The accused has also failed to explain as to why, according to SFL report, the organ phosphoric pesticide was found in the vomiting of the deceased. Therefore, the trial court rightly draw an inference that the accused appellants were guilty of the offense for which they were charged. Hence, we find no merit in the
You did not again. Our question was that 304B is the substantive charge where there is material. Our question was that why 302? And it is a 302B na. ଶହ ଜଜମେଣ୍ଟ ଆପଣ ସେଦିନ ବାହାର କରିକି ଦିଆହେଲା ଆଉ। P04 ତ ଅଛି ପ୍ରକାର। You have understood your case, Mr. Pradhan?
Madam.
What is your case? In your case, the appellants have been convicted in the offense under section 302. 304B. All right. So as far as the offense under section 304B, evidence is crystal. But what made the court to convict the appellant under section 302? When the dead body has been disposed of, there is no postmortem, and the factum with regard to the homicidal nature of death is not before the court. Still, the court held that the appellants are convicted under section 302. So, one of the foremost ingredients to convict a person under 302 is the homicidal nature of death. So, how do you presume from this record, this evidence, that the court had sufficient material to presume that the case is one also 302? That was our question. ସେ ଯୋଉଟା ଦେଖିଲି ସେଥିରେ 302 ଚାର୍ଜ ହେଲାନି, ଆପଣଙ୍କର 302 ମତେ ନା, ଆଉ କୋଉଥିରେ ଆମେ ଡିସାଇଡ୍ କରୁ?
Yes. There is no dispute that the deceased was in the company of the appellants, because it was the matrimonial house, and the father has stated, father is PW 12. He has stated that when he got this news and came, he was told by the accused persons that Pratima committed suicide by jumping into the well in the night. And when I asked them as to why he did not inform my brother, brother-in-law, or me, or police before cremating her, they replied that it was night and it was not possible to intimate us regarding the death of Pratima. And I told them that the well in the backyard is so small that a bucket would, in much difficulty, could enter it, and how my daughter committed suicide. So, prathame eita thila apanଙ୍କର statement before the father.
Before the inform.
Right?
Yes.
Now you changed it to be that it was a colic pain.
Yes.
In the 313 statement.
Yes.
And all on a sudden the colic pain and
Died.
so what is your case? It was 106 ଯଦି applicable କରିବା, ଯଦି ଆପଣଙ୍କର ତା ବାପା ଆସି ପହଞ୍ଚିଲା ବେଳୁ ଆପଣଙ୍କୁ ପୁଣି ସେ କୋଉକୁ ଡେଇଁ ପଡ଼ିଲା,
Occurrence took place in 11 well, they came to 14 well after 4 days.
ଆପଣଙ୍କର statement we are not, the 40 କେବେ ଆସିଲା we are not, ଆପଣଙ୍କର statement ଯେତେବେଳେ ଯେଗୁଡ଼ା କହୁଛି, when I came to the house of the person, asked him his sons and wife, means this, that
Period
how my
13.
daughter died, all of them replied that. ତେଣୁ ଆପଣଙ୍କର first statement before the informant, that it was the death has taken place in this manner. ଆପଣଙ୍କର plea during suggest ଯୋଉଟା କଲେ witness ମାନଙ୍କୁ during trial and also in the 313 statement, it was a colic pain, natural death, and we intimated they did not. And so is it not inconsistent ଯୋଉଟା ଆପଣ ତାଙ୍କ ବାପାକୁ ପ୍ରଥମେ କହିଲେ informant କୁ ଆଉ ତାପରେ ଆପଣ trial stage ରେ project କଲେ, is it not inconsistent? Now the deceased was with you, you cremated the dead body, burden shifts to you, so you are to say that how the deceased died. So once you are prosecution has discharged their initial burden by proving all these things, that she was in your company, and rightly pointed out that dowry demand, all these things, even previously also you have brought, all these things are there. ଯେତିକ ଜିନିଷ ଆଣିକିନି ଥୋଇଦେଲେ, ତାପରେ ଆପଣଙ୍କ ପାର୍ଟରୁ ଆସିଲା ବେଳକୁ ଆପଣ ଡେଡ୍ ବଡି ଡିସ୍ପୋଜ ଅଫ୍ କରିଦେଇଛନ୍ତି, The question is that natural death रे dead body dispose of करिसेंती बेली जो plea टा नौचंती 313 statement रे, that is contrary to your statement at the first instance before the informant. So, and the law requires that you are to discharge that burden. 106 टा ସେମାନେ foundation देला परे आपण ही burden discharge करिवे तो आपणकर जो जहाँटा आपण plea टा आनी थौचंती, it is not acceptable because evidence has come in that very village, the relations
Yes.
of the deceased were also there. ताकू भी आपण intimate करें. Let us say that he was in Raulkela, he could not have waited for some
Information.
but what about the other family members? ସେମାନେ ତ ଆପଣଙ୍କୁ କହିପାରିଥାନ୍ତେ ନା, ପୋଲିସକୁ ତ ଜଣେଇଲେନି, ତାଙ୍କର ଯୋଉମାନେ ବାପ ଘର ଲୋକ ଆପଣଙ୍କ ଗାଁରେ ରହୁଥିଲେ ତାଙ୍କୁ ବି ଜଣେଇଲେନି, ପୋଡିଦେଲେ ନାହିଁ dead body ଟାକୁ dispose of.
And that part of evidence has not been dismantled, that some of the relatives were present in the witness.
ବାକି ଯୋଉ evidence ଟା ସିଏ ଆଣିଛନ୍ତି, ଯେତେବେଳେ ଆପଣ ତାକୁ କହିଲେ ସେ କହିଲା ଯେ ପୁଅଟା ତ ଏ ଟାଇପର ଗୋଟେ ବାଲ୍ଟି ହିଁ ଯାଇପାରିବନି ଆଉ ତା ଭିତରୁ ଡେଇଁକିନି ଜଣେ ସୁଇସାଇଡ କେମିତି କରିବ ବା ପଡିକିନି, ସେ ପାର୍ଟଟା ବି ଅନଚ୍ୟାଲେଞ୍ଜ ରହିଯାଇଛି। ଆପଣ କିଛି ଆଣିନାହାନ୍ତି ଯେ ନାଇଁ ଗୋଟେ ପୁଅଟା ଏମିତିଆ ଯେ ସେଠିକି ଜଣେ ଜମ୍ପ କରିପାରିବ, ସୁଇସାଇଡ କରିପାରିବ, ଏଇ ଏଭିଡେନ୍ସ ହିଁ ଆଣିନାହାନ୍ତି, ନା ତାଠୁ ଆଣିଛନ୍ତି ନା ଆଇ ଅପାଠୁ। ତେଣୁ ସେ ଏଭିଡେନ୍ସ ଟା ଅନଚ୍ୟାଲେଞ୍ଜ ରହିଗଲା, ସେ ଯୋଉ ଆପଣଙ୍କୁ ଚ୍ୟାଲେଞ୍ଜ କରିଛି। ତେଣୁ ଏଇ ସର୍କମଷ୍ଟାନ୍ସ ରେ ସୁଇସାଇଡ ଟାକୁ ଯଦି ରୁଲ ଆଉଟ୍ ହଉଛି, ଆପଣଙ୍କ କଣ୍ଡକ୍ଟ ଟା ଯୋଗୁ ଯଦି ଏଇଟା ବି ରୁଲ ଆଉଟ୍ ହେଉଛି, then the
only inference
it is murder, and murder is also a unnatural death, so we can be
I think Vijay in her deposition has stated he has intimated the informant. And
that is all how you have substantiated.
You see, the moment you say so, informant must have also contacted that yes, I am not going to reach there. You be in the cremation, तार relation वाले थिले पूरा घर पाखे just think of it, the visualize it. Informant चुपचाप झियो कथा जानला, झियोटा मरी जाइछि, से चुपचाप ही रही जीवो ना तुम पोड़ी दियो, कहबनी एमती कौन एमती झियोटा ठीक ठाक थिला पोड़ी गला मरी गला केमती, तार रिलेशन माने पाखरे जा देखो कौन हेछि तार ये
no, what does the prudence demand in this situation? The prudence demand that either he will ask the neighborhood to be present, the police is to be informed. So that is the prudence. Then you could have been absolved of your involvement. But did it happen? Surreptitiously, you went for the cremation. You did not even inform the relatives. And one phone call to the person, in-laws, is enough. So that is all these activities from your side appears to be PC. Some relative or the members of in-laws would have come. What was there? कौन एमती थिला जे ताको 8टा सुधा निहाती ये जळे देवार थी.
That is the reason why we asked you to find out the decision on that light. So once the natural death is ruled out, suicidal death is also ruled out. These decisions are there. That 302 conviction is. Suicidal death is a plea notion, inconsistent plea that has been taken at the first instance. That is not consistent. Suppose say plea ta semane sustain karithante till the end of the trial, matter would have been different. Switch over karigale semane totally कहले it's a natural death. पिठा खाई ଦେଇଥିଲା ତ ପେଟ ମୋଡିଗଲା ମରିଗଲା ତାପରେ ଆମେ ପୋଡିଦେଲୁ ନାହିଁ, ତେଣୁ completely different.
କରୁଛନ୍ତି କଣ ଆପଣ କହୁଛନ୍ତି ତ ସବୁ କରୁଛନ୍ତି
କଣ? We have given you sufficient time, and we have given also that how to find out the decisions, where you will get the decision, how you will get the decision. ଆମେ ସେଦିନ ବାହାର କରିକି ମଧ୍ୟ ଦେଖିଲୁ ଭର୍ତ୍ତି ହେଇଛି decision. In spite of that, if you do not search, then what can we? ଯୋଉ decision ଆଣୁଛନ୍ତି 2 ଜଣ ଯାକ ଆଣିଛନ୍ତି ଏଗୁଡାକ totally irrelevant. It is not befitting to the case in hand. ଆଉ ସବୁ କଥା ଯଦି କୋର୍ଟ କରିବ, then what assistance the court will get from you, both of you. The question of life of 3 persons, all of them have been sentenced to life imprisonment. ପାଞ୍ଚ ମାସ ଭିତରେ ବାହାଘର ଡେଥ୍ ହେଇଛି। 18/5/97 ବାହାଘର ହେଇଛି ଆଉ ଅକରେନ୍ସ ହେଇଛି
11/10 ନାଇଟ୍
11/10/17
11/10/17 ନାଇଟ୍
11/10। ତ 5 ମାସ ବି ପୁରିନି ତାକୁ ଘଟଣା ହେଇଛି। ସେଇ କଥା ମଧ୍ୟ ସେ ଏତଲାରେ କହୁଛି ଯେ ଖବର ଆମ ଗାଁରେ ଥିବା ମୋର ବଡ ଭାଇ ଓ ଶ୍ୱଶୁର ଘରକୁ ମଧ୍ୟ କୌଣସି ଖବର ଦେଇନାହାନ୍ତି।
ତାଙ୍କ ଶ୍ୱଶୁର ଘର ବି ସେଇଠି,
ହୁଁ
ୟାର ଅଜା ଘର ବି ସେଇଠି,
ହଁ
ପାଖ
ଆଉ ଝିଅର ଅଜା ଘର ବି ସେଇଠି।
we are
miles.
So you see your explanations about the death of the deceased and cremation, what the witnesses have stated. You start from PW1. PW1 raw page 60. The mother-in-law of the Pratima informed me that she died due to fall in the well, and I protested why, without informing us, they cremated her dead body, though we are residing a little distance, while I was still near the house once. So, accused Vijay took me and police to the cremation ground where the dead body of Pratima was still burning. Accused Vijay poured 2 buckets of water, extinguished the power. Police seized one. So,
And this witness is residing very close to the village. He could reach immediately in half an hour.
The contextual statement he has stated the police came on 12 mile. What the
see,
his context
1 year after the marriage, I got the information that somebody that Pratima had been killed in her in-laws' house at Swanson. I reached Mandar about half one. The husband of the Swanson, his father and mother and younger brother were there in the house. Sethi,
the mother-in-law
information diala thi.
PW1 and 11 to 161 statement nahi first time se maine
Just let us see.
The
You have confronted this. It is not a fact that I have not stated before the police that Sarojini informed me that Pratima died by fall into the well and that I protested so and so. Okay, where have you brought out this, proved this to the IO? Who is the IO?
PW 14 mile.
14.
Yes, technically FR and all is 14 mile.
No,
What the PW?
just don't hear it.
Page 90 mile. Page 90.
90.
Yes.
Read it out.
On 14/10/97, I was a SI in charge.
See your confrontation part was that is in 93.
93 man.
I have not examined PW1 on 12/10/93.
93%.
Page 93.
Cross examination.
On 15/10/97, I examined PW1 in village Jiruli, but I have not stated the time of such examination.
Noted the time.
I have not noted the time of such examination. I have not examined him in the police station. He has not stated before me that Sarojini informed him that Pratima died by falling in the well. That he protested why the dead body of Pratima was cremated without informing them. That police seized dowry articles from the house of accused Ronka in his presence. That accused Vijaya with the fire in the cremation ground. The police in his presence seized the burnt flesh, bone and ash from the cremation ground. That the accused Ronka took gold and silver ornaments in his jima and executed the jimanama. I have not examined PW1 on 12/10/97. PW1 has stated police came on 12/10, my lord.
Wait, let us. এটা হলো এখন আদিকন্দ নায়ক।
Yes,
আদিকন্দ নায়কের ইয়েটা ভাগ
কেস ডায়েরি আছে। Yes, separate কেস ডায়েরি আছে।
কেস ডায়েরি আছে।
Page 61 में देखो, the 125 ওটা কোটা আছে না 61. On he was examined on 15/10/97.
তার নাম কোন হলো? আদিকন্দ।
আদিকন্দ।
10 on 12/10/97.
Yes, my lord.
He heard the one from Panu and family murdered their daughter-in-law.
Are you on a
And-
PW 14?
I have the PW 14.
and put the dead body inside the well, and we have a collar of 9 side. Remove the dead body by one program and burn the dead body hurriedly by pouring kerosene oil before sunrise on 12/12.
Okay, then you come to the evidence of PW 11.
Yes.
The on
11 also stated that the police came on a 12, my lord.
no, পড়ন্তু evidence টা পড়ুন আর जो ইয়েটা
Yes.
এই जो particular লাইনটা you come to page number 74.
Before me that she was a
No,
torture.
ଅଛି early in the next morning ମଝିଆ ମଝି ଅଛି early in the next morning I got the information from the guard that some or somebody else in our tow that the dead body was being cremated. I went there immediately and found accused Panu, accused Bijay, eldest son of accused
Eldest son of
Panu and
accused.
some other person who
Other,
I do not know.
I do not know
Were
the
cremating a
dead body. I had asked them why they were cremating a dead body in our tow and whose dead body was cremated. Accused Panu and his two sons told me that the wife of eldest son of accused Panu died in the night due to stomach trouble and they were cremating her dead body. I returned to the village and took some villagers with me to show them how in my talk the dead body of the daughter-in-law of accused Panu was being cremated. At about 10 a.m. on the same day, police came. My lord, your lordship can see them. 12 minutes. He has stated the police came on 12, my lord. At about 10 a.m. on the same day, police came and ascertained from me if the top in which the dead body was cremated belonged to me, and seized ash, kerosene bottle, and some bones and earth from the place where daughter of accused Panu was cremated, and prepared seizure list.
No, so from this evidence, at least this much is coming that the accused persons were participating in the cremation of the dead body. Right? Now, and what information has been given to this PW11 that the there was a stomach trouble.
Yes.
Hello?
Yes.
So PW11
has stated the stomach trouble.
Right. Stomach trouble taku କହିଛନ୍.
Yes.
Stomach trouble.
Yes.
Hello?
Yes.
Okay. Now, यार किसी contradictions ଅଛି କି ଏଇ ଯୋଉ part ଟାରେ?
ସେ କହୁଛି ସେ ବି ସେ 12 ରେ ଆସିଥିଲା ପୋଲିସ କି ମନା
ନାଇଁ,
କରୁଥିଲା
12 ଫେଲ୍ ଛାଡ଼ନ୍ତୁ.
କୋଉଠି 12 କୋଉଟାକୁ ଏତେ insist କରୁଛନ୍ତି ବୁଝେ? So what? Why are you insisting on that?
Whether there is any contradiction so far as this that they disclosed that it was due to stomach trouble, what they disclosed, is there any contradiction to that effect? PW11 ର କୋଉଠି ପଚରା ହେଇଛି, confrontation ହେଇଛି?
Page 94 में.
Page
94.
94 ଅଛି, ସେଇଆ କହୁନାହାନ୍ତି. Confrontation ଏଠି
I have examined
Yeah.
ରୁହନ୍ତୁ ମୁଁ ବ୍ୟସ୍ତ.
I have examined PW 11 on 14/10/97.
Yes.
I have not examined him on 12/10/97. He is native of village near Aska. It is not a fact that I have visited the cremation ground on 10 a.m. on 12/10/97. PW 11 has not stated before me that the eldest son of Panu married in village Mandara. That 2 to 3 months after marriage, Panu complained before the leading villagers that his daughter-in-law was misbehaving with him and other member of his family and requested the intervention of PW 11. That he went to the house of accused Panu, and before him the son of Panu, the wife of Panu, and Panu himself in presence of daughter-in-law of Panu complained that his daughter-in-law was misbehaving like a chandi, showing disrespect to them. That the daughter-in-law was complained before him that she was being tortured by her parents-in-law, husband and brother-in-law, to bring the balance dowry amount from her parents. That the daughter-in-law of Panu desired to go her parents' house, but was not allowed by Panu and others of his family. PW 11 has not stated before me that 5 to 6 months after marriage of daughter-in-law of accused Panu, she died. That one evening between Ashtami and Dasami, the daughter-in-law of accused Panu had gone to Durga Mandap with Prasada and returned back. That after some time they heard shout coming from the house of accused Panu, and he along with the others went there. That the daughter-in-law of accused Panu complained before him that the prasad was thrown away and she was assaulted by her parents-in-law, husband, and his elder brother Vijay. That they advised them not to create skin and told the daughter-in-law to go to sleep. PW 11 has not stated before me that early in the morning, getting information from the somebody that the dead body was being cremated in his top, he went there and saw accused Panu. Accused Vijay was with others were cremating a dead body. That the accused Panu told him that in the night his daughter-in-law died due to stomach pain. That he returned to the village and took some villagers with him to show them how the dead body of the daughter-in-law of accused Panu was being cremated in his top. That about 10 a.m. police came and ascertained from him that he was the owner of that top. That on the same day, police seized articles from the house of accused Panu. PW 11 has not stated before me that he saw staining of blood of the wall in the house of accused Panu.
Okay, now in this, so far as PW 12 is concerned,
Yes.
who is the father?
Yes, my lord.
Now that paragraph number 2 is relevant.
Yes.
We
Police
read from-
along with me and others went to the father of one ponda of a village Mandara and seized from it some burnt pieces of bones, some half burnt human flesh, and some charcoal from it.
Now you read on 14.
On 14/10/97 at about 5 p.m., I went to the house of accused Panu and asked him, his son and wife, how my daughter died. All of them replied that Pratima committed suicide by jumping into a well in night. When I asked them why they did not inform my brother-in-law, and me or police before cremating her, they replied that as it was a night, it was not possible to intimate us regarding death of Pratima. I told them that the well of their backyard is a small,
small.
Small that a bucket would in much difficulty could enter it, and how my daughter committed suicide jumping into that well. Police in my Jima released the ornaments given to my daughter during her marriage, except a necklace of 2 tola, the wooden articles and other articles, except some costly sari. I executed the Jima, is my signature. I do not know the accused who had put a red napkin on his shoulder in dock. I have not seen him earlier. I know the accused putting a white shirt in dock as the relatives of accused Panu, but I do not know his name. Except accused Ranka Panu, Sarojini Bijo, and accused Sahadeva, who is the maternal uncle of accused Panu Swai. I do not know the names of other accused persons, but I know some of them are relations of accused Panu. I have visited village Mandara 8 to 10 times before.
No, so far as this
Before-
confrontation part is concerned,
Yes.
about the information that was given,
Yes.
that has been suggested or confronted in paragraph number 5, page 82.
Yes, sir.
Last 5 lines.
Yes.
It is not a fact that I did not state before the police that on 14/10/97 at 5 p.m. I went to the house of accused Panu Swai, asked him how my daughter died, and he told me that Pratima committed suicide by jumping into the well.
The articles I have been taken in Jima from
So,
police.
this has been proved through the IO. IO evidence is speed of page 95 actually.
PW
Page
12
90.
has not given the marriage Chuktinama, Nirbandha Chuktinama, and a marriage photograph of his daughter with accused Lankanidhi. PW 12 has not stated before me that on his return home from duty, he heard from his wife and children that PW 1 over telephone had intimated that Pratima was killed in her house and her dead body was cremated without informing them. That the in-laws of Pratima demanded from him. That his daughter told him that she was also tortured by her brother-in-law. PW had not stated before me that on 14/10/97 at about 5 p.m. he went to the house of accused Panu and asked him the cause of death of his daughter. That accused Panu told that Pratima committed suicide by jumping into the well. PW 12 has not given me the list of dowry articles given to his daughter at the time of marriage. I have not received a receipt from PW 12 granted by the pool of residents showing deposit of Rupee 21 before the marriage of his daughter. I have not seized burnt pieces of bones, half burnt flesh, and some corpuscle of the father of PW 10 in the presence of PW 12.
You see, this part there is some kind of contradiction.
Yes.
But about the other part, demand of dowry, torture to the deceased, consoling the deceased, all these things which he has stated prior to that, there is no contradictions. କାରଣ ସେ PW12 ର evidence ରେ ଦେଖିବେ ସେ I paid 60,000 at the time of marriage as dowry. They demanded 60,000. I paid gala. ତାପରେ on the marriage pendal, I handed over term deposit of so and so. Then I called my daughter to my house. She informed me that her husband, father-in-law, mother-in-law, brother-in-law, so and so, always taunting her that the accused Ronco had married elsewhere. They would have got more than 1 lakh rupees towards dowry only. She also informed by time that she was assaulted by her husband, father-in-law, mother-in-law, brother-in-law. I consoled. Eguda kichi contradiction nahi. I consoled my daughter not to lose heart and assured her that I will get the things managed. My daughter stayed with me at Raurkela for 2 months. ମାନେ 5 ମାସରୁ 2 ମାସ ସେଠି ରହିଲା, during which accused Panu went there and demanded the rest 20,000 rupees as has been told by so. I incurred loan of rupees 10,000 and gave it to Panu Swai. The relations of the accused Panu and Sarojini are also at Raurkela. In their presence, I handed over 10,000 to so, granted me a receipt which the police has seized from me. I promised to pay the rest of the amount of 10,000 within 1.5 months and told the accused Panu that my daughter should not be tortured by her husband, brother, mother-in-law, so and so, as we established relationship for 7 generations. Accused Panu returned back with my daughter on so and so, hala,
At 12:10.
at 10:30 when I returned to my house after finishing this one, so my wife told me that cousin brother of my wife telephonically informed to my neighbor that my daughter was killed in the in-laws house and her dead body has been cremated without information on 14 Tariq acid.
Up to that it is.
So this part is there. The marriage and the death, the gap is about 5 months,
Yes.
out of which 2 months almost he is remained in Raurkela with her parents. And prior to the marriage, there was a demand, and part demand was fulfilled, but the demand continued, and there was torture, and he was assaulted, and the father consoled her daughter. Then when again rupees 20,000 was demanded, out of which 10,000 was paid. A receipt was there. That receipt was seized by police, and the balance 10,000 rupees was supposed to be paid within 1.5 months. And then you brought that to the house, and on 12/10 this occurrence has taken place. 11/10 took place, 12 he got the information. And this part there is no such contradictions. So from this, if we find that marriage is within 7 years, right? Demand is proved, torture is proved, and your plea that it is a natural death. That means you
Stomach pain.
stomach pain पण पिठा खाई ଦେଇଥିଲା ନା?
If,
that is not acceptable, and this then remains that it is natural death. Excluded means unnatural death. So unnatural death this suicide theory which you have projected, that is also very doubtful feature, that ପୁଅକୁ ଦେଇକିନି ଯୋଉଟା କି statement ଅବଶ୍ୟ has been stated by the father. এই ପାର୍ଟରେ contradiction ରହିଛି. And the very close family members of the deceased, they were residing in the very same village, and you disposed of the dead body without informing them, and that too also not in the regular place where perhaps the cremation was made. It was done in that PW1 that you कहूनी ମୋର ଇଏରେ ଆସିକି ସେମାନେ ପଢୁଥିଲେ ବୋଲି.
PW11. 11 minutes.
So that was not a regular cremation ground. ठीक होची
That ଉପରେ ଯୋଉ.
that ଉପରେ ପଢୁଥିଲେ. I asked them as to why they were cremating the dead body in our toe, whose dead body was cremated. ସେଇଠୁ ସେମାନେ କହିଲେ ଯେ stomach trouble ପାଇଁ ହେଇଛି. So there was nothing on record that the deceased was falling from any fever or something like, or she was quite hale and hearty. There was nothing, no problem with her health. So and you disposed of the dead body.
You could have adduced evidence to substantiate this.
And what was required I think suppose ଆପଣଙ୍କର one case ଥିଲା ଯେ ବାପା ପାଖରେ ଯୋଉଟା କହିଲେ ଅବଶ୍ୟ contradiction ଆସିଛି ଯେ it is a unnatural death, then you are required to give information to the police. That also you have not done. Even for that, an offense is there, 176 IPC. Omission to give notice or information to public servant by person legally bound to be. So whoever being legally bound to give any notice or to furnish information on any subject to any public servant intentionally omits to give such notice to furnish such information in the manner and at the time required shall be punished with so and so. So once you would have given the information regarding this unnatural death, as you said that jump karigala se jo well, then UDK inquiry heithanta, postmortem heithanta to know the cause of death. So this thing could not be done because you cremated the dead body. So, Bottoman, if the natural death is ruled out and there is no evidence of any, your plea that it is a natural death is not acceptable. So if it is not a natural death, then either suicide or homicide. So suicide ପାଇଁ ଆପଣ କିଛି evidence ହିଁ ନାହିଁ ଯୋଉ ଜିନିଷଟା ଆପଣ ବାପାଙ୍କ ପାଖକୁ କହିଲେ of course contradiction ଆସିଛି ପୁଅକୁ ଡେଇଁ ପଡିଲା ତେଣୁ ତାର ନାହିଁ ତେଣୁ
so even if we ignore that, that means there is no plea of suicide also. It was a plea taken by the PW, yes, but was contradicted. So that means there is no plea from your side that there was suicide also. But then homicide is a must.
And once it is unnatural death, that is also unnatural death. So 304B, 302 simultaneously charge can be framed. So there is nothing that once you say that it is 3042, it cannot be under 304B. A lady, suppose he during that period of 7 years he was subjected to, and ultimately for that he is killed, let us say. So he can be also convicted under both the offenses. What is there? If you rule out the homicidal death, right, then he may not be convicted under 302. But if it is homicidal death is also, that is also unnatural death. Yes. So many decisions are there. A person can be convicted both under 302 and 304B, provided that that aspect is proved, but not the alternatively. Suicide pramanita hela, he cannot be, obviously, he cannot be convicted under 302. But if the prosecution proves that it is a homicidal death, simultaneously prove that the other ingredients of 304B, 7 years marriage, dowry demand, torture, all these things, then he can be also found guilty. कौन पे खुजी ना वही जो ଦେଇଥିଲି लिस्ट ଚାଟା
ଆସିନି
Receiver. What will I see? Hajari डाकिए. I'll show you all those decisions which I have found. Wait, yes. If that 2002 106 SCC 530. Take filter. It is 530 para protein. 530. 530 तो 530 भाई. हाँ. नहीं 5 से 30 हुआ. 5 से ना. हाँ. Last paragraph कट के देखिए. Duty for circumstance would have some of the 14. The next question is the very discussion. Right, sir.
Definitely, our circumstances are there. We have much better circumstances.
এটা দেখি এই ওটা 2002 র ভলিউম 7 157 purpose directly not concrete production because paragraph 13 basically times of this level. He wants to
Portrait drawing prosection. Division. Seven and nine. STM counseling. So the notice to the parents.
The charges can be framed and convicted also. Person can be charged and convicted both under section 302 or more. Very good. Somebody has died on Saturday. Right. Then he be convicted on the 302. If the other ingredients are met out, let us say that the way took this within 7 years. There was consistent demand of solid and the pursuit was also information that you found and take has taken this only said so whether here we will be convicted on the system 30 and not in the 30 would be or both the offenses can be charged and be on the equal stage. What do you see?
For B.
Is it case of homicide?
Yes.
Into ingredients would have no 304B or Motam method, like 7 years marriage, dowry demand, torture information is without it. Is supports. That's why no homicide and question. Whether it can be found under 302 only, or 304B only, or 304. So the charge frame each detail.
We are not on sentence.
Yes.
Ambition.
304B.
304B. 304B. That is your school. We said that they tell you how many. Who better want to eat the year?
Will be the state of the you will be in this law.
No.
That cruelty must have been meted out soon before that.
Yes.
7 years.
Within the period of 7 years. Within the period of 7 years.
Operate that under normal circumstances. Whether murder is covers under that or not. Visual would be there. Who ଟା ଓଭରରୁଲ କରିବ ବିଜୁ ଫୋର ଅଛି ବହି ଅଛି dates are excluded on P04. What are those two dates?
Commission not amount model. P04B calculation.
Dates are excluded from the purview of section 304. Where the death of a woman is caused by any birth, particularly or occurs otherwise than under the normal
circumstances. Within 7 years of marriage.
Accidental death is ruled out, natural death is ruled out, a beta death ruled out. Baki unnatural death plus even murder of the that would also come. That would be additional charge saving because that is also not under normal circumstances. Not examine these things. Or bodily injury or occurs otherwise than under the normal circumstances. What are the normal circumstances? Death. How many reasons are there? But if it is not proved to be a homicidal death, then even if the charge has been framed under P03 and P02, the conviction cannot be under P02. But once it is proved to be a homicidal death, then also if the other ingredients are, that is the decision. The charge, first of all, charge can be framed both under section so and so, right?
Yes.
And conviction can also be. Sentence is a different, but that can be done. Provided that ingredients are, it is not necessary for 302 to establish guilty, to demand a dowry. Only homicidal death and the author of the crime sufficient. But 304B, in addition to that, I know to find the presumption as you of 113B. If these are the charge A periodically, that will be consistent with right only 9 therefore it's illegal to decisions are there. He upon the यदि हमें एक केस से उनकी natural death जहाँ बचाव जो हो natural death का हमें अपन को जो pre-nation
Yes.
if we do not accept it, suppose, and if the accidental death is not there, your case is also not of suicidal death, which of course you have stated and there are contradictions. So the only impedance is the suicidal death. କୌଣସି ରୋଗ ନଥିଲା ତାକୁ ତାକୁ ସାରିକି disposed of କରିଛନ୍ତି ତାର previous ଇଏରେ ତାକୁ ପୁଣି ମାନେ consistently torture ହଉଛି ମରାମରି କରୁଛନ୍ତି ସେ ଯାଏ ବାପଘରେ ଯାଉଥିବା ରହିଛି ତାପରେ ତାକୁ ଆଣିଛନ୍ତି 10,000 ଟଙ୍କା ଦେଇକି ଆସିଛନ୍ତି ତାପରେ immediately ତାର death ହେଇଛି ଏବଂ ସେଠି ଆପଣ କିଛି ତାର ସେଇ ଗାଁରେ ରହୁଥିବା relatives ମାନଙ୍କୁ ନ ଡାକି cremation ground କୁ ନ ଯାଇକି ଆଉ ଗୋଟେ ଜାଗାରେ ପଡୁଛି these are the circumstances. There are some contradictions to the other parts, but the main aspect is upon how you escape. ଆପଣଙ୍କର ସ୍ପେଶାଲ ନଲେଜ ଆସିବ ଯୋଉ ଜିନିଷଟା ଆପଣଙ୍କର ସ୍ପେଶାଲ ନଲେଜ ଆସିଲା ମାନେ ଲିଡରସିପ ସମୟରେ ପ୍ରସିକ୍ୟୁସନ ଏଇ ଜିନିଷ ଗୁଡାକ ପ୍ରାଇମା ଫେସି ପ୍ରୁଭ୍ କଲା ପରେ ଅର୍ଡରଟା ସିଫ୍ଟ କରିଯିବ ଆପଣ ଆଉ ଆପଣ ତାକୁ ଡିସଚାର୍ଜ କରିବାକୁ ଆପଣ ଫିଲ୍ ହେଇଛନ୍ତି ଯେ ଦିଟା ଫିଲ୍ ହେଇଛନ୍ତି ଗୋଟେ ହଉଛି ତାର ନ୍ୟାଚୁରାଲ ଡେଥ୍ ଏବଂ ଆମେ ତାଙ୍କୁ ଇଣ୍ଟିମେସନ ଦେଇଥିଲୁ କିନ୍ତୁ ସେ ଆସିବେ
Point put that point put. Yes.
କିନ୍ତୁ ନ୍ୟାଚୁରାଲ ଡେଥ୍ ର ଇଏଟାକୁ ଆକ୍ସେପ୍ଟ କରାଯାଏନି ଆପଣ ତାଙ୍କୁ ଇଣ୍ଟିମେସନ ଦେଇଛନ୍ତି ବୋଲି ଯୋଉଟା ସେଇଟାକୁ ଆକ୍ସେପ୍ଟ କରାଯିବ ନାହିଁ because of the other family members are stated also like that in case of the chance why the that the condition is achieved. For obviously, for completed the question under section 302, there is no need of buffer hearing. The number is the practically upon 40 years. Practically upon for a stream with very that. But otherwise, it has been that the date has taken place and it is the omissed.
There are nothing.
So if you only the postmortem because you are responsible.
Yes.
Upon ही जो नहीं है, तो कभी अपन legally wrong, so that you relation you cannot say that postmortem नहीं करो, miscellaneous तो हमारा नहीं, that you are the creator of prosecution to basic so that one कर ला तो हमारे whether the prosecution अबू केस दरकार the postmortem the argument that no all the cases where the postmortem has not been conducted and the doctor has not opined that it is a homicide and then there cannot be any conviction under section 302. Whereas the upon then there are a number of issues that not have postulated on so many distances. So we are sorry to say that evaluation is not if ponderable fully at the decision value is after all the how is the entry upon video way. So then to lack interest of to dishonor the data on the factual scenario upon what actually see what the divide. The data to it acts and very download upon put a software the we could have a data decision and this. There are more SCC 157. They are 1991 Supreme 1226. There are all the cases where the dead body has been displayed. Right. How the court has analyzed the evidence and came to hold. That's probably I just got it within 15 minutes. So you are given 2 days time. We want that you should search and more on, and particularly whether a person can be convicted under both when the charges have been framed under section 302 and 304B, whether he can be convicted under both the offenses. And if so, then how it can be done? What the prosecution is required to do? And have you searched Monu?
Yes. Search my search.
SCC. SCC. That is very easy. Library ଅଛି ଆମ judges library ଅଛି ଏଠି ଗଲେ you type it for a Monu search ଟା ବି ଅଛି ନା Monu search ରେ ତାদের ଲେଖନ୍ତୁ ଦାଉରି SCC proof of the dead body disposed किसी डॉट फॉर किसी दे यहाँ पर है 302 ना
Yes.
how IPC video 4B मतलब How will you see 304B or related cases segregate someone? How will that body disposed?
304 भी IPC.
Yeah.
ଅଗଷ୍ଟ 28 ତାରିଖରେ yes ହଁ ବୋଉକୁ ଧରି ମନ୍ଦାର ଗ୍ରାମକୁ ଆସିଲେ 28 ଅଗଷ୍ଟରେ ଆସିଲେ ଅଗଷ୍ଟ 28 ତାରିଖରେ ପାଣୁ ସ୍ୱାଇଁ ଝିଅର ଶ୍ୱଶୁର ରାଉରକେଲା ଯାଇ ବଳକ ଟଙ୍କା ମାଗି ଝଗଡ଼ା କରିବାରୁ ବୁଝାସୁଝା କରି 10,000 ଟଙ୍କା ଦେଲି ଏବଂ ଅବଶିଷ୍ଟ 10,000 ଟଙ୍କା ମାସେ ଭିତରେ ଦେବି କହିବାରୁ ପରେ ସେ ବୋଉକୁ ଧରି ମନ୍ଦାର ଗ୍ରାମକୁ ଆସିଲେ
डेट 12/10
11 ନାଇଟ୍ ଗଲା ଖାଇଲେ
ଲୁଣ ପାଣି ଲେମ୍ବୁ ପାଣି ଦେଲୁ ପିଇଲେ
appellant 2 already expired
Saturday next time.
appellant number 1 is 85% bed did in person now
the condition हो segregate करिए yes it is then you segregate that no this the grant can be
no